Are y'all good?
Yes, sir.
Okay. Good morning, everyone. The time is 9:02 a.m. on Wednesday, September 18th, 2024. I hereby call this September Code Compliance hearing to order. For these hearings, we usually follow an agenda, a copy of which is posted outside of this room. The first item on the agenda is the call to order. We just had that. The second item on the agenda is the pledge to the flag. So I'd like to ask if you join me in the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based. Thank you.
Okay, the next item on the agenda, item D, is to deal with the minutes from the Wednesday, August 21st Code Compliance hearing. I have reviewed a copy of the proposed minutes. Are there any proposed objections or modifications to the minutes as currently formulated? All right, hearing none, I'm going to go ahead and sign and approve the minutes.
Staff update, abated and continued cases are listed out front.
Okay. So good morning, everyone. My name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. Now, that's a fancy title created by the law, but what it means is that Citrus County has hired me to preside over this hearing today. What I'm going to tell you during this opening statement applies to all of your hearings, so I'd like to ask that you pay close attention. When your case is called, please come forward, and you will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call its case, and I will allow the county to present its case first. You will then have an opportunity to cross-examine any of the county's witnesses, and you will also have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case to me today. I will ask whether or not you are contesting the violation. So if you don't argue or contest that a violation exists, I will assume that a factual basis for the violation does exist. But I will ask you how much time you need to fix it. So a fine won't immediately begin to accrue. I'll grant 30 days, 60 days, something that's appropriate for the violation to bring it into compliance for you to work with the county before any kind of fine begins. So if you don't argue with the county about this, it's important that you let me know early on in the hearing to save time for you and everybody else. Now, you're not required to do that. If you argue that a violation exists, that's totally fine, and you'll have an opportunity to explain to me your defense. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak in each case. Such right to speak is not unlimited, and public comment should be focused on the case at hand. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you should not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must fix the violation by the date that I give, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose that fine on a lien on all of your property. The county has the right to foreclose on that lien or seek a money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their case or the liens that may happen, I encourage you all to seek legal advice. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate this into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs, as well as the cost of the lien imposed. Although it's only happened a few times in my years as a special master, I may continue your case if I find a need for further evidence or argument. I do ask also that you silence any phones just so we can all focus on the hearing at hand. It may be today that I end up continuing hearings because we have a lot, and my understanding is that we have one at 1 p.m. So what that means is we're going to break for lunch. We're going to break for lunch around noon. If we don't get to your hearing by noon, I'll talk about it with the county, but just so everyone knows, I may have to continue your case to the next hearing. I've reviewed the agenda. You do have the right to appeal any order that I make today as provided by law, and that's all I've got, so thank you very much.
First case on today's agenda, Bobby John Kirby and Sayonara de Fredes Soares, case number 2024-01273. Correction. Case number 2024-00465. License and Compliance Officer Timothy Williams, page 25 of your agenda. Expert on the case, Certified Building Official Samuel Costa.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your names for the record.
Bobby John Kirby Jr.
Sayonara de Freitas Soares.
Thank you.
Thank you. Good morning.
Good morning.
Good morning.
Good morning.
Please proceed. Hey.
This is a case about a non-permitted home, and they are appealing your lien,
No, you're the fine appeal.
fine appeal.
It's a fine appeal,
Yes,
okay.
Yes, sir.
So this is a case where it came before me. I found that a violation occurred. Let me just read from the agenda. I granted 60 days from the date of the order, which apparently was on May 16th, to abate the violation. If it wasn't brought into violation, a $150 a day fine would be imposed. And I guess, Mr. Williams, is it the case that you found the property was not in compliance in the time allowed?
Correct. I
All
did.
right, so then I would have signed an order imposing a lien, correct?
Yes, sir.
Do you have that in evidence?
Yes, I
Or do you
do.
have it? So before I just want to understand what happened before I hear what your appeal is. Can you show them what you've got? Because I'd like to see it so that I understand what happened. So, sir and ma'am, I'd like to ask you to take a look at this and just let me know if you have any objection to me having this as evidence in the hearing. I think it's a copy of my order, which I just need to understand what happened.
Tim,
Tim?
the findings of fact, is that what you
Yes,
gave
it
him?
looks, it looks like our, we had 60 days to comply with the order.
So that's a copy of the order, right?
Right.
I just want to know if you have any objection to me having it as evidence in this hearing.
No.
Okay,
I have no
I just
objection.
want to take a look at it. Thank you. All right, let me just take a look at it real quick to remind myself what happened. All right, well, guys, this is your, sir and ma'am, this is your appeal, so what's the basis for the fine appeal?
We sent the plans out to get the revisions of the plans, the way I understand it, back to compliance to address all the issues that were involving the permit. And we submitted it within the 60 days and through the third-party reviewer that we were required to use by the county. And then for some reason, the county decided they wanted to do their own review, and that held up from being entered back into, I guess, the permit being issued. It looked like just a few days. But we did address the issues within the 60 days and submit them. I believe they were uploaded in the portal. This is Bill Berry. Bill is our builder,
Okay,
and I trusted him from the beginning to push this stuff through. So
Ms. Berry,
he's-
did you develop the plans, or are you a contractor?
No, I'm a contractor, yeah.
Okay, all right.
Well, yeah, the third-party inspection company, was slammed all over the state, was the same way. And then when he got back to the county asked for an additional FEE number, and then the portal was down, we uploaded it. And, we felt like we did, to the best of our ability, to get it in there on time.
Okay.
But then they did a final plans review, which held it up even longer, so.
All right, Mr. Williams, is the property in compliance as we speak today?
Yes, it is.
When did it come into compliance?
August 15th, the permit was issued.
So did you hear anything that you disagree with from the respondents regarding their submission and
I
getting
do not-
something within before the deadline?
I don't have any knowledge on their permitting.
Okay. Mr. Acosta, do you have any knowledge?
I'd have to research it. I don't, you hired a private provider to do the plan review and inspections, correct? And then I believe when you submitted that, we might have had some review comments regarding
Yeah.
their submittal.
Dawson and yourself emailed back saying you're doing a plans review, and it took an additional 2 more weeks. And,
It was review comments from Dawson?
yeah.
So it was in a flood zone?
It was an email with everybody's name on it together, yeah.
That probably had to do with the paperwork that's submitted, informing us that you're using private provider. That's probably what that was. Now, whether
What does
they're-
that mean? I mean, does that mean that you didn't know who the provider was, or you
No,
were checking their?
There is there's certain forms you have to fill out with certain information. And so if it's lacking in that information, Dawson would have said, hey, by statute, I need this.
Yeah.
You identify who your guys are.
Right.
Doing the work and how they're licensed and such like that. There's several things that could,
Right.
be incorrect in the submittal, largely administrative in nature.
So according to this information, Mr. Williams, you started your case on March 11th, 2024, at which time the violation was confirmed. There was a residential site-built home being constructed without a permit. Subsequent inspections were conducted on April 17th and May 14th. The notice of hearing came out on April 22nd, and you had contact. And Mr. Berry, you testified at the code hearing, I believe, yeah.
And if I would have known how busy the third-party companies
Yeah.
were, I would ask for 90
This case started on March 11th.
Yes, sir.
Is there anyone from the public who wants to be heard on this case? Appeal denied. Thank you.
Thank you.
This case started 2 months before it ever came before a hearing. I understand about the delays, but it should have been handled immediately. And it wasn't until after I had to find that there was a violation. So I deny the appeal. Thank you. And you can appeal my order to the court. Thank you. Next case?
Yes, sir. Next case on today's agenda, Deanna Jerry G. Williamson, case number 2024-00715. Licensing Compliance Officer Keith Gardner, page 42 of your agenda. Expert on the case, Samuel Costa, Certified Building Official.
Good morning.
Good morning.
Ms. Williamson, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much. Please state your name for the record.
Laura Williamson.
Hi, good morning.
Good morning. Keith Garner, License Compliance Officer, case number 2024-0715, Article 18, Chapter 18, Article 1, Section 18A. Obtain after-the-fact permits for all construction or modifications of the Citrus County Code of Ordinances. Address is 11664 West Clayton Drive, Homosassa. Deanna J. Williamson. Good service via posting at the property in Lecanto Government Building. And I'd like to authenticate the following documents and request they admitted into evidence. This is uncontested.
It is not
It
contested?
is right.
All right, let me hear that from Ms. Williamson herself. Are you contesting whether a violation has occurred on the property?
No, I'm not. I just need an extension.
All right, how much time do you need?
60 days?
Does that sound reasonable to you? Is this something that can be corrected? And the reason why I ask both sides is because, as you just heard, sometimes there are delays with paperwork and reviews, and we don't always know how long it's going to take. I won't set you up for failure. What do you think?
I don't have a issue with the 60-day extension.
What needs to be done here from your
To
perspective?
apply for a permit for, I believe you extended a seawall up to some degree.
So what had happened was, before we made any adjustments to the seawall, we actually called Citrus County. They said that we didn't need anything. When the hurricane came through last year, it damaged part of the seawall. So we were just trying to fix it. We tried to call, we tried to do the right thing, and then we found out that we didn't do the right thing.
Yeah.
So now we're trying to do the right thing.
No, I get that. So you're talking about a permit for a seawall extension or modification?
It would-
I guess it's a repair at this
It's a
point.
repair.
Repair.
That doesn't seem that complicated.
No.
Do you need engineering on that, or what do you need?
I would not, I'd call for engineering on
Okay.
that. Yeah.
She's actually been working with Quincy, she's been actually working with Quincy upstairs.
Yeah.
And has some other things that she's been working on, so.
Okay, then what I'm going to do is I am going to grant 60 days. I'll find that there's a violation. I'll grant 60 days. If it's not brought into compliance in 60 days, I will assess a fine. What's the county's recommendation?
County's recommendation is $50 a day, along with administrative costs to begin after the date you deem sufficient.
That's the smallest amount the county ever requests. So I am going to find that if it's not brought into compliance in 60 days, a fine of $50 per day. But I've been informed that's a reasonable amount of time to get this done. Okay?
Sounds good?
That's it. Actually, is there anyone from the public who wants to be heard on this case? All right, that's it. Thank you.
Thank you so much.
Next two cases on the agenda, Susan E., David M., and Christine M. French, case numbers 2024-1336 and 2024-1337. Code Officer Cody McGuire, pages 13 and 14 of your agenda.
Good morning, sir.
Good morning, sir.
Yes, sir. Yes, sir. Very next case.
Hey.
Morning.
Sir, do you you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right,
Please
thank
state
you.
your name.
My name is David French.
Thank you, sir.
Good morning.
Good morning. Cody McGuire, Citrus County Code Compliance Officer. Case numbers, there's two of them.
And we're presenting both at the same time?
Yes, sir.
Okay.
Yep.
Now, sir,
Tuesday-
just so you understand, there's two cases here on the agenda. They're at the same address, and the county is going to present both cases at the same time. Do you have any objection to that?
Understood.
I'm sorry?
Understood.
Okay. Personally, I favor it that way. It usually takes not as long, but all right, go
Understand.
ahead.
Case number 20241336, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. And case number 20241137, unlicensed inoperable vehicle, a violation of Chapter 20, Article 6, Section 20-41 of the Citrus County Code of Ordinances. Address is 10059 North Denellen Road. Dunedin Road, I'm sorry. Property owner is Suzanne E., David M., and Christine M. French. Good service sign, certified mail return receipt, and posting at the Canto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A's, photos taken during initial inspection on July 25th, corrective action inspection on August 9th, and photos of my final inspection conducted on September 17th, 2024. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail return receipt, and a pre-hearing order.
Okay, so sir, they're trying to introduce evidence that includes photos and some other documents. I'm going to ask them to show that to you first. And let me know if you have any objection to these documents being evidence in this hearing. And take your time.
Oh, so you decided to walk all the way up into my driveway, huh? Okay.
was trying to do a posting as well.
No, you don't need to. We'll get into that. So I
Okay.
just need to know if you have any objections.
These are a bunch of photos. Where the documentation? Is it at the bottom?
I think it's been represented that there's a copy of the notice of violation and the notice of hearing, as well as some other notice documents.
And these are the ones that I already have.
While we're waiting, I'm curious to know, is there anyone from the public who wants to be heard on this case? I don't see anybody. Okay. Mr. McGuire, what are you, is that a second for the second case?
Yes, sir.
Okay. Are the photos different?
Some of them
Okay.
are the same.
Well, my question was, are they the same or different? Are there some differences?
Yes, sir.
Okay, all right. So, sir, do you have any objections to these documents being evidence for these hearings?
Well, I notice he does not have the date that the first letter was had been served to me.
The what?
The date that I got the very first notification of the issue.
Mm-hmm.
Because this is written on the 25th. It wasn't mailed till the 29th.
Mm.
With the hurricane, I didn't get it till the 6th. That gives me 2 days. Now, my question to you is, how long are you required to give me for time to be able to deal with these situations?
You mean in terms of the time period between notice and the hearing?
Yes.
It's a good question.
Because I got 2 days.
Well, you got 2 days before the notice, right? So
No, I had 2 days in order to be able to meet compliance according to this paperwork, sir.
I see what you're saying. Well, that'll be interesting. Actually, we'll talk about
I
that.
have another question.
Well, before we get to that, my question to you was, do you have any objections to these documents being evidence in this hearing? So I need to know that.
Being as some of them were basically attained without, in order to attain, he had to trespass, therefore breaking the law, making them male eligible.
Okay, so your objection to some of the, not all the photos, correct? But
Correct.
some of the photos, is that they were obtained by unconstitutional ways, correct?
sir.
All right. Mr. McGuire, do you understand, and we'll let the county attorneys also weigh in, but do you understand what he's saying?
Yes, sir.
Did you ever take photos of this property from another property?
No, sir.
Okay. Where were all of the photos in each case taken from?
Most of them were taken from the roadway, but I did try to do a postman's walk to the front door where I found that there was a fence.
You said you tried to do a postman's walk?
Mm-hmm.
So you tried to do a postman's walk on the front yard and
Correct,
to
down
the
the
front door?
Correct. Down the driveway to the right, which there was a fence, which I did not go in. I
Let me
left
just-
my post or my door hanger on the fence.
All right, let me take a look at this just to see if I can understand what you're talking about. So for the record, code enforcement officers do have the right to engage in what's called postman's walk. They're not allowed to do anything else on the property, but they are allowed to do a postman's walk, which may entail walking to the front door, to a mailbox, things like that. So that I'm just going to look at the photos to see if I can determine whether that's the case or not. Is that the county attorney's understanding of what the postman's walk is? Okay. I do find that the vast majority of these photos are taken from the roadway. It doesn't appear, yeah, and I see what you're talking about, Mr. French. But I do think that's probably on a postman's walk. In other words, the driveway.
He walked past my gate in order to get some of those photos.
Well, what I'm going to do is you've made your objection for the record. From what I've seen on the location of the photos, I'm going to overrule the objection and admit them as evidence. And before I let the county present its case, I have reviewed the photos and other documents. Do you contest whether there's a violation in each case? And that's fine if you do, but do you contest
There
it?
was at the time,
Okay.
of which I attempted to clean up and get as straight as possible. I also attempted to inform him to be able to contact him on the 8th, of which I did.
Okay.
I left him a message, of which it took him over a week to get back to me, of which when I contacted him and left him a message, I told him, I need to know what else needs to be done to make compliance.
Okay.
By the time I got a call back it was the same day I got notification of hearing,
Gotcha. All right. Well,
which was on the 15th.
there's two issues here. One is the notice issue you've raised, which I still haven't ruled on, which is did the county give you enough time to comply before a hearing was set? Or,
2 days.
Well, right. So I haven't dealt with that yet. I'm going to look at it. But the second issue is I do have photos that were taken yesterday, and I still haven't heard the county. I'm going to hear from the county. But
Where's the ones from yesterday? I haven't seen those yet.
you have. They're all in here. And I think they're pretty persuasive on both cases. But I want to hear from the county first, and I'll show you the photos again. Please proceed.
Okay. On July 25th, 2024, I conducted an initial inspection and observed the property to be in violation. A notice of violation was issued for junkyard conditions and unlicensed inoperable vehicles, which are violations of the ordinance listed above. On August 9th, I conducted a corrective action inspection and observed the property remained in violation. I had contact with the property on August 15th, 2024, when we thoroughly went over the violations and had to abate them. And on my final inspection on September 17th, the property remains in violation.
So he's testifying that you say owner. I see 3 listed. Do you mean Mr. French?
That would be me.
I know who you are.
Suzanne is deceased and my sister is in Daytona.
So, okay, so you spoke with Mr. French here, correct?
Yes, sir.
All right. Do you recall that conversation on
Yes,
August
sir.
15th? Okay. Here's what I'm struggling with. I see, you have two cases. One is for an unlawful accumulation of junk, debris, rubbish, vegetative matter, stuff that's not stored in trash cans, basically, if that makes sense. It is in the code section. I'll share a copy with it if you need. The other case has to do with a violation based on storing, placing, depositing abandoned, unlicensed, inoperable, junked, discarded, or otherwise unused vehicles on the property. Mr. McGuire, how many vehicles are subject to that case?
Right now, it's just the scooter.
Has he made improvement on that case?
Yes, sir.
Oh, okay. So you have made improvement on the unlicensed vehicles case. Are you aware of the scooter being
Yes,
at
sir.
issue?
It belongs to somebody else. I'm waiting for the person to come pick it up.
Okay. And how much time would you need for that person to come pick it up?
I've been waiting for almost 2 years, so it might take a little while.
Well, no. It's going to take a reasonable amount of time. 2 years is certainly
I can have that scooter moved today.
correct. I mean, that's going to be my point. I'll give you a reasonable amount of time. I'm not going to require it today. But let's talk about the junk case then.
It's all been cleared out.
Okay, so you're saying that as of today, because as of yesterday, it certainly wasn't.
This is why I'm curious to see which photo you're looking at, sir.
Well, that's why we gave you an opportunity to look at them, and I'm going to show them to you again.
And none of those were recent.
Yes, there were several from yesterday, and I'll show them to you.
Okay.
So there are several file cabinets. Like one is really rusty. There's a storage bin. There's other like plastic containers that appear to be junk. Honestly, there's stuff that defies. There's a beautiful cat, but there's. Is that your cat?
Most likely.
Oh, do you have a few?
I have 2.
Okay. This one is white and black with like a black nose.
My Siamese, yes.
What's the name?
Nemo.
Nemo. Good name. All right, so these are all taken yesterday, and I'm just going to show a couple of them to you. Just give me a second. Yeah, all right. Can you show these? These are pages 15-17, 16-17, and 17-17 of Exhibit A in the junkyard case. You'll notice a timestamp at the bottom of the photos of September 17th.
Most of that stuff's
Mr.
already
McGuire,
been
can
dealt
you
with.
testify? Did you take those photos yesterday?
Yes, sir.
Okay.
Most of that stuff's all been dealt with.
All right. So if I give you 14 days to bring the property into compliance, you won't have a problem because it's already done.
Yeah.
Okay.
Exactly what all is in that photo is not in compliance, other than the filing cabinets, apparently.
A lot.
Which is where I
So
keep my
there's like I
flammable.
said, the cabinets, what appears to be an old bookcase with other junk in it, a lot of discarded materials and items, spray cans, handlebars, shelves. Looks like a discarded stool, an unused thermos, a tipped over and open and moldy cooler. So that you're clear, I'll go ahead and read from the code section of what all is encompassed in this. All right. All right. So this is for junk and debris. Debris is defined as material which is stored externally, exposed to the elements, not otherwise completely enclosed by a walled roof structure, and shall include but is not limited to the following: discarded household items, inoperative machinery, appliances, refuse, rubbish, trash, or junk, scrap, or discarded lumber, pipe, steel, plastic, glass, paper, cardboard, plumbing fixtures, and other building material. Junk is defined as any abandoned property, construction or demolition debris, litter, waste materials of any kind, used or unserviceable automobile or machinery parts, used or non-functional furniture or appliances, or used and non-functional tools, equipment, and implements, but shall not include compost piles for normal, personal, or commercial use in their proper location. Rubbish shall mean combustible and non-combustible waste material other than garbage. And that's essentially it. So, I mean, if you've already cleaned it up, then it doesn't matter. But, based on this evidence, there certainly has been a violation.
Okay.
Okay. So what's the county's recommendation on this case?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $200 per day along with administrative costs to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask that the special master additionally find that it's a respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I have a copy of the notice of violation, and it says dated July 25th, 2024. Is this what was, and it says corrective action has to be taken by August 8th, 2024. Was this mailed or posted on the property?
No, he signed for that certified.
Okay, let me just, but I think,
Please show me my signature on that.
Oh, that was for the notice of hearing. I'm sorry.
okay, so for the notice,
I'd
I
like to
see,
see
I
my
think I
signature on
understand.
that one, too.
Sir, so just direct your comments to me, but
sorry.
what I'm doing is I'm asking him questions. So I see evidence of a signature at that address on, just for the notice of violation, not the notice of hearing, delivered on August 15th, okay? And now regarding the notice of hearing, which I think is what you were saying, is that you only had 2 days before the notice of hearing.
Correct, sir.
Okay. Well, I'm going to overrule that objection then, because the relevant time period is the time from the notice of violation to the time to correct. They can set a hearing, and so you had until August 15th to correct, not from the time of the notice of
Not
hearing.
according to the way this is written, sir.
Okay. I mean, I've seen some copies of it. Based on the August 15th deadline on the notice of violation, that's enough time, I think. So I'm going to overrule the objection. I'm going to find that there is a violation in each case. I'm going to give you 14 days in each case to abate the violation. Sounds like you're already done, so that won't be a problem, but it's important to make sure that it is done in each case. So, for example, you have to abate in the junk case 24-1336 all this junk and debris there. It's either got to be put inside the house, otherwise enclosed, or removed from the property. On the unlicensed vehicles case, that scooter has to be removed from the property or has to become suddenly licensed and operable. But whatever the case, you're going to have 14 days from the time I sign the order to bring it into compliance. Now, the county has asked for I think you said $200 a day. I'm not going to have that amount. I'll make it $100 a day in each case, but that's if it's not brought into compliance as ordered. In each case, there will be a $100 a day fine.
Okay.
Do you have any questions?
Yes, I attempted to contact him to make sure that I was within compliance.
Well, no fine has started yet.
I understand
Yeah,
this,
so
sir.
there's I understand what you're saying, but my point is this has to be fixed now within 14 days. Let them know. Keep a log, of the time that you've reached out, that kind of thing. But I think you're going to be okay.
Okay, well, my question is according to this, I had until the 8th to have it fixed and to call him, of which I did.
Okay.
Okay, the problem that I run into is I had 2 days to do this.
I've
Now,
overruled
you
that
guys-
objection based on the records that showed you had until August 15th with a notice of violation.
That's not what this says.
Do you deny that the notice of violation says what it says?
What I'm stating is what the notice of violation states.
It's irrelevant. Objection overruled. That's it.
Thank you.
Thanks.
Next case on
My-
today's
I do have
agenda.
one more question.
Okay, is it something you haven't said before?
Yes.
Okay.
Now, if I meet these requirements that you're requesting, and I contact him, who's to say he's not gonna drag his feet again and wait another week till after the compliance requirement date is over?
First of all, you've already testified it's done, so I'm sure all the requirements are already met. Second of all, he's already on notice as to the hearing. Are you gonna go out and inspect it?
Absolutely.
All right, do you know when you're gonna do it?
In 14 days.
Well, okay, yeah. So you're gonna have 2 weeks, so he's gonna come at or after the 14 days to check regardless of you calling in. Does that
Okay.
make sense?
That makes sense.
So he's coming.
So if I call him ahead of time.
Yeah. He's not under, honestly, it wouldn't even make sense to do it because you have 14 days, but that's with them. So who's to say they are? If you find that you've brought it into compliance and upon their inspection, they find that it's not brought into compliance and you disagree with that, then you appeal the resulting order. Does that make sense?
Yes, but that doesn't answer my question, sir. My question is if I bring it to what I assume is in compliance and I call him ahead of time prior to the date that I'm required, does that mean he's gonna come out and tell me
I don't
what
think
needs
they're
to be
required to
done?
do that. I think they're required to do it at the end of the period that I gave you. So I would just work with them and try to work that out.
I tried to work with him, sir, and
Sir,
he waited a week to call
I've
me
already
back.
addressed this. This is the end of the hearing. Thank you.
Okay.
Good luck.
Next case on today's agenda, Sean Gauss, case number 2024-1286, Code Officer Julie Wilkinson, page 15 of your agenda.
Good morning.
Good morning.
Is Amy Becker still retired?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
do.
Thank you, sir. Your name, please?
Sean Goss.
Good morning.
Good morning.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2401286. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6440 South Bryson Point in Homosassa. The property owner is Sean Goes. I have good service via signed certified mail return receipt. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on July 15th, 2024. Photos from a corrective action inspection on July 30th, 2024. And photos from my final inspection conducted on September 17th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
My objection is not all of these photos are on my property.
Okay. Yeah, I'll take that up. In other words, you're saying that these are photos of other properties besides yours, some of them.
Some of them,
Okay.
yes. Definitely some of them.
Is there anyone from the public who's going to want to be heard on this case? All right, I don't see any response. And also, just to be clear, are you contesting whether a violation has occurred on the property? And that's fine if you are. I just always try to save time if you're not arguing about
Yes,
it.
since some of this evidence is not my property, yes, I am.
Okay, what I'm just talking about is your property. I mean, do you contest whether there's a violation on your property?
Almost all of this was on the property line,
Okay,
and it's vacant property that I do not reside on, and I did not place it there, so yes, I am contesting it.
okay.
And the vast majority of this is not my property.
Well, so you keep saying the vast majority. Is any portion of the violation on your property?
Some of this is on the property line, so yes.
Okay, I mean, all right, then let's go through this. Let's talk about it. That's fair.
Okay.
Thank you. Let me just take a look at these. Now, Ms. Wilkinson, let me just ask you a couple questions as I look at these. You've heard the objection. Is it your understanding that some of these photos show another property besides Mr. Gaz's?
Yes, they show a private road, which the property owner owns up to half of the road. So,
Okay. Well, so I guess the answer is yes.
Yes.
Some of these photos do show property that's not just his, correct?
yes, sir.
Okay. And what is the purpose of showing portions of a property that are not his?
Because he owns to the middle of the private road, and that's where the stuff is located.
Okay, so as I look through these, it's your understanding that I'm looking at some photos where it shows a violation that's on the private road over which he has half ownership?
Yes,
Or at
sir.
least up to a line?
Yes, sir.
I object to that.
Okay. I mean, it sounds consistent with what you told me. You know, you said that you only own up, and there's most of the violation is on someone else's property, correct?
The roadway is a defined parcel.
The roadway is a defined parcel?
Yes, it is a defined parcel with a width, and I do not own that roadway. I do not own halfway.
To the best of your
into it.
knowledge, who owns the roadway?
The person's name is Brett Allen Johnson.
I still think that so it's interesting. You say, is it a private roadway?
Yes, sir.
Is it owned by Mr. Johnson?
There's a
Well, it's
parcel
owned
ID
by
here.
whoever's properties are adjacent to. So there's two properties that are on. So there's two different property owners next to the roadway. So there's two
Right.
property owners of the roadway.
It has its
So
own
I
parcel.
think, so here's the issue. Sometimes when there are vacated roadways and vacated rights-of-way, then the neighboring property owners will own to the center line once they're vacated. Is it your testimony that this roadway has been vacated? Are the county attorneys aware of this issue? No. Okay. Do you know what I'm talking about? And that's
don't.
okay. So let me just ask you, Mr. Goss. So is it your understanding that, as we sit here today, that roadway has not been vacated?
Considering it has its own parcel ID and there's an owner on file.
And when
it
you
is
say
not
owner on
vacated.
file, are you talking about the property appraiser's office?
Yes.
Okay. And to the best of your knowledge, since I'm not hearing from others, is it just that roadway that's owned by Mr. Johnson, or is it like a grid or a?
He owns the parcel directly behind my parcel 2, and the roadway, my belief is it gives him access to his property, which is behind mine.
To the best of your knowledge, do you have any? I have no evidence to believe that you own any portion of the roadway, but do you know if you have any access rights on that road or an easement?
Best of my knowledge, no, I do not.
How big is your lot?
2 acres.
Okay. Is it a platted lot? Is it meets and bounds? Do you know?
I would assume it's platted.
Okay. So, Ms. Wilkinson, let me ask you this. Is any portion of this violation not on the roadway? Because let's just set that aside. Let's assume that Mr. Goss is right. Is any portion of your case dealing with property that's unarguably owned by him?
Without a survey to show exactly where the property lines are, it would be difficult to determine.
Okay.
And
I'm concerned by this. I mean, it is possible for people to own roadways, especially private roadways. And what I think I'm going to have to do is continue the hearing, Mr. Goss, because I don't
Okay.
have any.
I do want to state,
Yeah.
as far as the junk that was on my property line, I have removed that.
Well, that's the thing I guess I'm having trouble understanding, because you did say at the beginning of the hearing that a very small portion was on your property.
Property line.
And you're saying,
yes.
well,
It-
there's no,
I know.
the line is a fictitious thing. It's almost invisible,
Understood.
right? So I'm not trying to, what's the phrase, split hairs, but I think that you originally basically testified there was a portion of junk on your property. And now I believe you're testifying that although that's the case, it was removed.
Yes, I had never put it there. This owner of the roadway, my belief is he's responsible for all of it. In the photographs, there's a large piece of farm equipment and piles of logs behind it, which is definitely not on my property. There's also a pile of logs that is on my property, and it's my belief, since they're the same type of log and everything, that whoever places there also placed them on my property.
Are you saying those logs are on your property today?
Yes, that is the only thing I have not been able to remove, because it's a big pile of logs.
I mean, is that part of your case?
Yes.
Okay.
They're like,
So I have bad news, Mr. Goss. That is something that is in violation of the code. Now, the county has the ability to go after a property owner even if you are not the person who put the logs.
Understood.
They also have the ability to go after who did it. Ms. Wilkinson, do you have any knowledge or information as to, if it wasn't Mr. Goss, as to who would have been responsible, especially given your photos that show so much on the other property?
Yes, well, yesterday, when I was at the site, I spoke with a surveyor who may be a property owner for the parcel on the other side of the road. And he told me that the logging equipment and the tree debris was from a neighbor across the street who owns a tree company. But I haven't confirmed it yet, but I do have their contact information.
So, just based on what, I want to make sure I understand what you're telling me. Is it your understanding that this is dumping essentially by a third party?
It could be dumping or it could be storing.
Right.
I guess,
right.
yeah.
Right.
just want to reiterate, is vacant land that I do not reside at. I wasn't aware of it until the notice.
Here's the deal, though. Again, the code section's pretty clear about how this applies.
I understand.
So these are heavy logs. I mean, these are not things that someone can just walk and pick up.
Mm-hmm.
Let's say, Mr. Goss, that I found that there was a violation. How would you get rid of the logs?
Great question. I probably would have to hire a third party. And considering they are old and decaying, I'm not sure if they would be solid enough to remove.
Is it the county's position that, Mr. Goss is responsible for this?
Yes, for his property, he's responsible for what's on his property, yes, sir.
What's the county's recommendation on this case?
$50 a day.
That was wise. I'm going to give you a sufficient amount of time to resolve this. And what I mean by that is I'm hoping that you will be able to induce your neighbor or whoever is responsible to fix this, assuming the county doesn't go after them. I am going to have to find that there's a violation on this property.
Okay. The vast majority of it is definitely not on my property.
Yeah, I'm not
so-
going to make a finding. What I am going to find is that to the extent any of this is on another property or the private roadway, since I have no evidence that you own the private roadway, only to the extent that it is on your property inside your property line. Does that make sense?
Okay.
Yeah, and that's what I'm going to find. And I'm going to give you 3 months to bring it into compliance. I'm hoping that's enough time to induce the responsible parties to do it, if you know who they are or can find them, or alternatively, unfortunately, to handle it yourself.
Okay, since this is a parcel that, has a defined owner, you're saying I'm responsible to contact them about the debris on their property?
No, you are responsible to fix the violation on your property. How you do it is up to you.
Okay.
I'm suggesting that one of those
Okay.
ways
I
is
just-
to get a third party to handle it.
I just want to be clear that
You are
you're not
responsible.
asking me
I have been clear. You are only responsible for what is in your property
Okay.
line, very.
And I
you know,
will not worry about the rest.
That is not something the county can force on you, or I can. I cannot, and I wouldn't. So, all right. Now, if it's not brought into compliance within 90 days, then a fine of $50 a day will accrue.
Okay, as a statement of fact, would you like me to read the parcel ID of this roadway?
If you want, I mean, I want you to lay your record.
Okay, the parcel ID of the roadway that the vast majority was on is 17E205-1A0000010. And the owner is Brett Allen Johnson.
All right. Thank you.
Thank you.
Next case is on the day's agenda. International Contractors of America, case numbers 2024.
These are all on different properties, so you're going to be presenting them one at a time?
Yes.
Okay.
I can do that, or I can do it all at
I think the
same
county's
time.
policy is to do one at a time, and that's fine.
Okay.
Yeah.
Okay.
Case number 2024-1127, Code Officer Alan Jonason, page 19 of your agenda. Expert on the case, Joanna Katu.
Joanna?
I apologize. Can I read my notes?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name, sir.
Javier Kaufman.
And Mr. Kaufman, are you a representative, I see your shirt, but are you a representative of ICOA?
Yes, I am.
Okay, are you an owner or authorized agent? Can you tell me a little bit?
I'm an owner.
Okay, great, thank you. Go ahead.
Good morning, Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-01127, Citrus County Land Development Code, Section 40.
Can you tell me that case number again?
2024-01127.
01127? Is that correct? All right, so on the agenda, I have 01181. That's
Okay.
not, it
Whichever
doesn't.
one- whichever one.
No,
he
well, that's none of the cases for ICOA, but
Yes, it is.
So,
I have 1130, 1129, 1181.
page 13 should be 27.
Oh, 13.
Oh, sorry, 23, sorry. Page 23
23.
should be 27.
So, oh, there's five? There's
Yes.
five of them. I'm sorry, I thought there were only three.
They're all in a row.
Yeah, they're all 5 neighboring
same
lots.
That's
I
why
got you.
that's
Okay,
why I
all
was
right.
saying
And
that.
actually, since there are five, let me just ask this. All right, Mr. Kaufman, are you contesting whether there's a violation on any of these?
I am not.
Okay. So, Mr. Jonason, I think we might be able to cut to the chase. That's often wishful thinking.
I think so too.
Okay.
I have photos and everything, and I've spoken with the property owner. They're working on permits from what I understand.
Okay.
But they have not had them issued yet.
All right, Mr. Kaufman, are these 5 residential lots?
Yes, they are.
And are y'all working on building houses?
Yes.
Okay. What do you, from your understanding, what do you need to do to fix this situation?
Well, the permits should be out. They should have been out months ago, but since there's been some back and forth between the county and I, fixing some little problems on the site plan or whatnot.
Problems on site plans matter.
Yes.
Yeah.
They should be ready by this week, I would say.
All right. Ms. Katu,
If I can jump in. They did apply in May. All of them have been ready for issuance since August 28th. The only thing holding is a mechanical contractor, an AC contractor. Once they get that signature, they can go ahead and issue all 5 of them.
Wow.
They're all
okay.
ready to go.
And that would abate the violation?
That would get them a permit in hand, yeah.
But so they have to, what would abate the violation?
Establishing a principal.
I think we're asking for a one-time fine for 5
Yeah,
of these.
there you go.
Oh.
One-time fine, be done, and you don't have to worry about it.
All right. And is it a one-time fine in total or on each case?
Each property.
How far along did they get before this came about?
When I first got the case, it had already been cleared.
What had already? Oh, the site had already been
properties
cleared.
had already been
Okay.
cleared.
Okay. I see. So normally, and so that you know, Mr. Kaufman, maybe you already do know, oftentimes the county will bring site clearing cases without a permit, because you need a permit to even do that. And honestly, I assess the fine. And it's normally, I don't know what but it's up to $5,000 is my authority. I don't normally do that.
We can-
What is the county, I'm sorry.
We can go up to 15.
Yeah, no, the county can go very, very high on this. What is the county's recommendation?
5,000 per property.
Okay. Mr. Kaufman, are you aware that that's what the county is going to be requesting?
No, I was not.
Okay. Do you wish to contest and hope that I find that there isn't a violation based on that?
Yes, I would like to contest, but
You know there wasn't a permit.
there was not a permit.
Yeah.
It was
Why wasn't there? I mean, I'm just curious.
well, we anticipated that the permit was going to be issued way before, and I'm going to be honest with you.
Thank you.
We wanted to have it cleared and prepped. We knew that we had to put trees down after the fact, but I did not think for once, it was a one-time offense. Trust me, it would never happen again. And we made that mistake, and
Yeah.
I assume responsibility. Hopefully, I
mean, that's
didn't want it to be
fairly rare
5,000.
that I hear those words in this hearing. I assume responsibility. So that's, I think, a mitigating factor. Look, if you want to proceed with the hearing, you can. I'm not going to do a $5,000 fine on each property, but it's up to you.
You are not going to do a
I'm not going to do 5,000. I am going to assess a fine on every property, though.
That's fine.
Okay. We'll assume a factual basis since there's not contesting. Frankly, ICOA has accepted responsibility. I am going to assess a $2,500 fine on each property, and I'll issue orders to that effect. Okay?
Thank you.
Thank you.
Thank you.
Next case on the day's agenda, Ernest and Gloria J. Ferguson, case number 2024-1158, and case number 2024-1159. Code Officer Brandon Norman, page 11 and 12 of your agenda.
Good morning.
Morning. I'm stepping in for my mom.
Okay, well, we'll just ask you to raise your right hand and swear an oath to tell the truth.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Bless you. Please state your name for the record.
Mandy Ayala,
Can you spell the last name, please?
Ayala.
So, Miss Ayala, who is your mother?
Gloria Ferguson.
Okay.
She passed away last month.
Okay.
So when this was,
Is Mr. Ferguson still around?
he's in New Hampshire.
Okay.
He's sick, so he can't travel.
All right. And are you, to the best of your knowledge, do you have any siblings?
My brother.
Okay. But you're an heir to Mr. Ferguson?
Yeah, I live on the property.
Okay. All right. That's what I needed to know. Thank you.
If it's okay with you, I'd like to present both, just because this is two properties that are side by side that don't have.
It's fine by me. It's
Okay.
up to your boss. So.
I'm good with it.
Okay. Very good.
Okay. Good morning, Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2024-01158 and 2024-01159. Both cases being accumulation of junk and debris violations of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This address is for 7899 East Wooded Trail and 7901 East Wooded Trail in Inverness, Florida 34450. Property owner listed as Ernest W. and Gloria J. Ferguson. And I have good service via signed certified mail return receipt. At this time, I'd like to authenticate the following documents requested be admitted to evidence. For both exhibits A, all photos were taken on the same date. They might be varying angles because they're adjacent properties.
Right.
But yeah. And then Exhibit B for both cases will be copies of the notice of violation, copies of the notice of hearing, copies of the pre-hearing order, and a copy of the signed certified mail return receipt for each respective case.
Okay. So, ma'am, I find that you have standing as the person who lives on the property to present here today. And what the county's going to do is show you proposed exhibits in each case. All right? And so what I want you to do, if you want, is to look through these documents and let me know if you have objections to them being evidence.
So this is for case 1159. This is for the 7899. And this is the 1158. What's that? Yeah, the 790.
Brandon, can you state the date of your photos?
Oh, I apologize.
So I just
When
want to
you
know,
go back.
Yeah,
no,
sorry.
and take your time. I just want to know if you have objections to them being evidence.
No.
Okay. Are you contesting whether a violation is on the property?
No, sir.
Okay.
I'm,
Then what we're going to do is we'll admit these as evidence. I'm going to admit exhibits A and B in each case. And I'm just going to look at them very briefly. It sounds like you're not arguing that there's a violation here. And I think on each case, it's what I would call a junk case based on the violation. Let me just look. Oh, go
Do
ahead.
we have the date of those photos?
Yeah,
just
I
for the record?
apologize. I said that they were all taken on the same date, but I
I
forgot
don't
to
care.
say the date.
It's not being contested. So let me
Understood.
just look at this and see if I can definitely, okay, I see what's going on. Are these two side by side?
Yeah, it's-
They're all
sorry.
like one,
we have it all as one.
I got you.
But I had just came down, because my mom just went back to New Hampshire. Where she moved out, we were trying to clean the house out, the yard was really bad.
Well, my question to you, I guess, is, I mean, I see it, I see the photos. How much time do you need to clean it up?
Well, we had somebody coming last night to drop off the dumpster and whatnot. The DCF, is that DCF, the Children, Youth and Families, that they're actually gonna pay somebody to come help.
The DCF is?
Yes, because I'm on Social Security, I'm disabled. Where she had just moved out, we were trying to clean up, I explained to him, and while he gave us 30 days, my mom passed away a week after he came.
Okay.
And I had to go to New Hampshire and deal with that, and by the time I got back, it was,
I get it. I mean, but that's why I'm asking you, how much time do you think you need to clean up the property?
maybe 2 weeks.
Oh, I mean,
We had
that's
we had them
reasonable.
dropping the dumpster and stuff off today.
Is there anyone from the public who wants to be heard on this case? I don't see anything. What's the county's recommendation?
Citrus County Code Compliance Division requests that the special master assess a fine of $100 per day per case, along with the administrative costs begin after the date that she deems sufficient to abate this violation. It was selected based on the actions of the property owners once they're revised, and it's appropriate given the severity of the violation. We'd also ask special master to find its respondent's responsibility to contact Code Compliance Division once the violations have abated to allow for reinspection.
I'm going to give you 30 days, okay? I mean, if you think 2 weeks is enough, I would think that 30 days is enough time, correct? So if it's not brought into compliance as ordered in 30 days, there will be a $100 fine
Yeah.
a day for each of the properties to the extent that's in violation. So if you get all the junk off one and just throw it over to the next one, there's still going to be a violation on that one. Does that make sense?
Yeah.
You've
Oh,
got to
yeah.
get it off the whole
No,
thing. No,
it will
okay.
be gone. We got everything out front in one big pile. He came. the
Yeah, I
other
mean, it
day.
looks doable, so I agree with you that you can do it in 30 days. That's it, that's the hearing.
Great.
All right,
Thank
thank
you.
you.
Next case on the agenda, Will France and Amy Virginer. Case number 2024-00785, Code Officer J.C. Charlton, expert Joanna Couture.
Good morning.
Good morning, sir. Good morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much. Please state your name.
Will Frank Verdiner?
Thank you.
It's Verdigner?
Verdina.
Verdina.
Yes.
Got it, thank you.
You're welcome.
Good morning.
Good morning. J.C. Charlton, Citrus County Code Compliance Officer. This is case number CE 2024-785, Special Requirements for All Accessory Structures in violation of Citrus County Land Development Code 3102A. The address is 5372 West Richland Lane, Homosassa, Florida. Property owners, Will Front and Amy Verdiner. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during my initial inspection on April 23rd.
Now you handled this case personally?
Yes, sir.
Okay.
and follow-up inspection on May 23rd, and corrective action inspection on August 2nd, and my final inspection on September 16th, all of 2024. Exhibit B, copies of the notice of violation, notice of hearing, a copy of the pre-hearing order, photos of the posted property, a copy of the posting affidavit I completed.
Sir, you've seen how this goes. I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
I also have Exhibit C,
Oh, I'm
is
sorry.
the property appraiser's report showing the vacant property.
Thank you. So just take your time. I mean, if you have an objection to these being evidence, let me know. If you're not contesting whether there's a violation, let me know that too. Mr. Tron, have you had contact with the property owners prior to this?
Yes,
Okay.
sir.
All right.
Yes, sir.
Okay, I mean, do you have any objection to these being evidence?
No objection, sir.
Okay. Are you contesting whether there is a violation on the property?
I've been going through a lot of my life. Me and my ex-wife were separated, and I was homeless. And I purchased a property. That's the only thing that I have to use as access to storage stuff that I had. I complied to the state because I had a shed, and I tried to order a permit, so they want me to remove it. I removed it, and I was asking the state to give me more time because I don't have no job at the time.
When you say the state, do you mean the county?
The county.
Okay, so you asked the county for more time?
Yes, for more time to remove the stuff. But I didn't have a job at the time. Then I have my cousin give me a job, I'm a CDL driver, so I was in the road.
You're a CDL?
Yes.
Okay.
So I was in the road, so it's not like an excuse I'm trying to
I understand.
come up with. So I was trying to make money to support my daughter, and I didn't want to comply to the state to remove the stuff. So now, when
How old is your daughter?
She 9 years old.
Okay.
And
And is she
then
with you full-time? Is she with your ex-wife?
She was my ex-wife.
Full-time?
Full-time.
Okay, but you're
And
supporting.
Yes, and the reason I bought this, that little tiny house thing, so I could have my daughter over the weekends, but the state didn't want me to have it there, so I removed it. So I just have my camper and my car, so I put all my stuff in the camper, and if you give me some time, I will comply for this.
Bring it into compliance.
Do compliance.
All right, so first of all, let me just go ahead and admit these into evidence. I've got exhibits A, B, and C. And Mr. Tron, let me just take a look at these first. Now, you had mentioned photos on the 16th, but I see one from the 17th. I assume that's slip of the tongue or?
Yes, sir.
Okay. all right.
Yes, sir. Correction, 17.
All right, I've seen the photos. You can proceed.
All right. Conducted my initial inspection on April 23rd of 2024. Observed vehicles, a shed, a camper, and debris on the vacant property, zoned rural residential. At the initial inspection, I was able to make contact with Mr. Verner. He stated he would work on resolving the violation and look into permits for possibly converting the shed into a tiny home. I gave him additional time also. Mr. Verner has been in constant contact with me. He called me when he removed the shed and stated that he was going to work on getting the rest of the items off the property, once he was in town from
Got
off
it.
the road.
So you have no reason to disbelieve anything he just testified to?
Right.
Right. How does this property get brought into compliance? I mean, so basically it's either removing everything from the property or what else?
Or establishing a principal use or home.
Is it possible to create a tiny home out of this? Do you know?
Refer to my expert witness.
Yeah.
Not that much of an expert on this, sorry. Joanna Coutu, Land Development, no.
You know more than I do, I can tell you that.
Converting an RV to a actual mobile, very, very difficult, very expensive. Much
Almost
cheap-
not worth it,
Yeah,
essentially.
Yeah, that would be just basically taking raw materials and having to redo it. So not easy.
So to the best of your knowledge, based on what is on the property, you're skeptical that it really makes sense to convert anything into a principal
Correct.
use?
There are tiny homes that actually meet Florida Building Code for residences, but that's not what that is.
Do you know, well, okay, thank you, I appreciate that. So what is your plan? I mean, based on your understanding, do you think you're gonna have to remove everything, or are you going to try and put a tiny home on there?
I mean, I went to Clinton Homes and tried to see if I could purchase one and make.
I'm sorry,
everything
sir.
legal.
Whose is this?
Oh, it's a phone.
Okay.
She's fixing it.
That can be
I thought it was a
fixed.
fire
It
alarm,
should have been
yeah.
fixed.
Yeah.
Okay. I'm sorry, sir. Can you
Yes,
please?
sir. Yes. I just apologize to the state. I wasn't in the road, so now I'm here. And
Well, that's another thing
just
you don't
wanna
hear
tell-
every day, an apology to the state. But, respectfully, I mean, I understand your situation. So I just want to know, I mean, do you think you're going to try and put this matters for how much time I give. So if what you're going to do is remove everything, that's a different time than establishing a tiny home. Does that make sense?
Yes, sir. Right now, at this moment, I'm just wanna clear the land and save money and do the right thing. So just go with legal and put a regular house and the land with permit and everything.
Okay. How much time do you need to get everything off the property?
Probably 30 days.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given to the severity of the violation and respondent's actions relative to this violation. We would ask the special master additionally find that it is respondent's responsibility to contact Code Compliance Division to allow for reinspection.
Is there anyone from the public who wants to be heard on this case? I don't see anybody. I'm going to give you 60 days to bring the property into compliance. If it's not brought into compliance after 60 days, there will be a $50 a day fine. Okay?
Yes, sir.
All right, good luck.
Thank you.
Thank you.
Next case on today's agenda, Power Sports of Minnesota Incorporated, 2020, case number 2024-192, Code Officer Julie Wilkinson, page 32 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Sir?
Oh, yes, I'm sorry.
That's okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And please state your name for the record.
Keith Scott from Keith M. Scott Construction.
Okay. And are you a contractor?
Yes.
Representative of the company?
Yes.
Okay.
It's a company, but it's an individual.
Oh, okay. Well, it says Power Sports of Minnesota Incorporated.
I'm here on basically Dave Rose's behalf, who owns it.
Got it.
He's probably got it, he's listed it under his business name, but that's who we're dealing
He's the
with.
principal. He
Correct.
owns the company.
Correct.
All right. So is this a fine appeal?
Yes.
Yes, sir.
Oh, okay. All right. So again, just the notes I have on this are that I guess it was probably me. I granted 30 days from the date of the order, which was June 20th, to abate the violation, which would have brought until July 21st. And I guess it was found to still be in violation. And I assume that this is like a vacant lot. Is that
Yes,
right?
sir. Yes.
Okay.
Yes.
All right. And so then you, I guess, probably signed an affidavit of noncompliance, and then
Yes.
I issued an order, correct?
Yes, sir.
All right. Is the property in compliance today?
No, sir.
All right. I'd love to hear from you.
Well, I'm in this on the back end of it. You got a lot more background with this than I do, but the David Rose approached me to build him a house. And I thought, okay, no problem. So I've got all the drawings done and everything for that. Then I find out it's all wetlands. So the issue now, and he's done a lot of legwork on this on his own too. prior to all of this, which I've been gathering all this information just over the last week. I didn't know about this hearing until basically 2 days ago.
Well, that's always fun.
So I just thought I'm here on his behalf just to explain what's going on with the property. There is an article or a document in the LDC Code 3102 that has special provisions for a boat dock on a property that's considered wetlands that's not buildable. It's a very short paragraph if you want me to read it.
What code section, do you know what subsection of 3102 it is? Yeah, I'm interested.
Well,
frankly, sir, I can hear the county attorneys. One of the issues here, and I talked about it earlier in the hearing, I'm just putting it on the record, is that normally in order to represent an owner, first of all, you have to have standing. And so normally, if you're not the owner, if you're not occupying the property as a tenant, you have to have like a power of attorney or some kind of a contract. I'm giving some leeway here, but I think it probably would be a well-placed objection. I am curious, though, as to what you have to say. So what code section are you talking about?
I'm looking at it. It says 3102 special requirements for all accessory uses.
I'm on there, yeah.
It'd be item A1. It says boat docks may not be installed on lots of record which do not contain a principal use of structure, which this dock has apparently been there for about 40 years. It was rebuilt and repaired, but it's been there for long before this code existed. And then under A, it says that the lot of record is undevelopable due to the presence of wetland or the lack of an ability to provide required infrastructure such as potable water, sewage disposal. I have an appointment with the FDEP on September 30th to determine what options there are to mitigate wetlands. And that's the only issue that's going on to be able to proceed with building.
There. What's on the property today?
Nothing, just a boat dock.
The dock.
That's
Okay,
it.
is that
There's a
the-
driveway too. There is an upland section of the property.
Yeah.
I mean, sir, here's the problem. I mean, ultimately, I'm interested that you said that it predates the code. If that had been presented at the original hearing, we might be having a different conversation, but it wasn't. I know it wasn't because I would have probably ruled differently.
I don't think the owner was here for the other hearing either, too. I
Yeah,
don't
but
think.
that's the other thing is
Right.
we already had it. So
Right.
this is just a fine appeal.
Right.
Normally in a fine appeal, the bases for a fine appeal include, is the property in compliance today? The answer is no.
Correct.
Is there another reason did I make a mistake? I do make mistakes from time to
No.
time. You don't hear that from lawyers very often either, with all due respect to the county attorneys, who actually are never wrong. But I just don't see it here. So, I mean, I understand why you're here, but I have to deny the appeal.
Well, that's all right. I'm basically here just to state a record that there is progress going on, but I don't have answers on the wetlands. Until I get those, there's no way the county is going to sign off on a building permit, so I have to go through the FDP
Right.
in order to get their approval to get the blessings here.
Yep.
It's a time frame it's going to happen.
My advice is that you keep working with them
Okay.
to make sure
That's
that
fine.
from the county side, and honestly, the only way that I know to bring this into compliance, short of getting what you're talking about, is to remove it.
Right.
I understand that's not what the owner wants, but that's my situation. So,
Am I correct? And I'm not sure if I talked to you on the phone, Julie, or whatnot, but if there is a CO issued for this property, that all the fines are abated, except for,
no, I would not, you'd have to beg the county essentially to do that.
okay, that's not on here, so that's.
It's not for me. I can tell you that's not a part of this hearing.
That's fine.
Yeah.
Okay, I'm sitting here blind, not knowing exactly how this works.
I get it.
But, okay.
But that's it.
I
That's all that I can deal with. So I'm going to
Okay.
deny the appeal, and I encourage you to keep working with the county.
Absolutely.
All right.
Yep.
Thank you,
Okay.
sir.
Thank you.
Next case, Pamela Lynn, case number 2024-01273, Code Officer Julie Wilkinson, page 26 of your agenda.
Do you you swear to tell the truth, the whole truth, and nothing but the truth, so help you
I
God?
do.
Your name, please?
Bradley Sparks, I'm her son. She is deceased.
Bradley,
Sparks, I'm her son. She is deceased.
thank you.
Okay. What page of the agenda is this?
26.
26, okay, so, and I'm sorry, sir, I didn't catch your name.
Bradley Sparks.
Mr. Sparks, okay, thank you.
Julie Wilkinson, Citrus County Co-Compliance Officer, case number 2401273. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6548 West Oak Lawn Street, Homosassa. Property owner is Pamela Lynn. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on July 15th, 2024. Photos from a corrective action inspection on August 15th, 2024. And photos from a final inspection conducted on September 17th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, sir, so your testimony.
I don't contest.
Okay.
I know that the stuff's on the property.
Okay.
I'm dealing with a lot of stuff, health problems myself, and dealing with my mom's passing and stuff.
Is that recent?
It was May 3rd.
Okay.
I am doing my best to get it cleaned up. I ended up getting pulled over for driving unsuspended. Had to get that taken care of so I could haul the stuff off.
How much time do you think you need?
Maybe another 2 weeks, and I should have it
Okay.
done. She should know that it changed drastically.
Well, let me hear
Since
from
the
Ms.
very first
Wilkinson.
one.
So first of all, do you think 2 weeks is enough time to do this?
No.
Okay. What I'd like to do is see the photos so that I don't set you up for failure. All right. So I need to know if you have any objection to these. I know you're not contesting the violation. This is a formality, you know. If you do have an objection, I'll hear it, but. And is there anyone from the public who wants to be heard on this case? I don't see anybody. Okay. All right. Do you have any objection to these being evidence?
The last few of the final inspection, it doesn't really show too much. It just
Okay.
shows like areas that are like, it doesn't show the whole property.
Do you have any reason to believe they're fake?
No.
Okay.
That's my only objection.
All right, so let me just take a look at them. Thank you. I do this so that I have a sense in my own mind about how long it'll take, and if people work around the clock, they're capable of a lot of stuff, but that's not usually what happens. I agree. I think it's unlikely to be 14 days. I wouldn't. What's the county's recommendation, first of all?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative costs begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
Are you your mother's heir?
My brother passed away, so yes.
Okay.
Besides my son that my mom adopted, but he's going back to foster care, so.
And so I just want to understand, are you going to be cleaning this property up alone? Okay. And how big is this property?
2 acres.
2 acres, I mean, yeah.
Well,
All right.
almost 2 acres, not quite.
It's 1.23 acres.
Okay. I'm going to grant 45 days to bring the property into compliance, and if it's not brought into compliance as ordered, $100 a day is going to be assessed. Okay?
Yes, sir.
Thank you.
Good luck.
Next case, Angela and Donnie B. Marcel, case number 2024-1175, Code Officer Brandon Norman, page 27 of your agenda.
Good morning.
Good morning.
Brandon Norman, Citrus County Code Compliance Office. Oh, sorry. I apologize.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Can you please state your name?
Donnie Blaine Marcel.
Thank you.
Thank you, sir.
I looked at you and I just dove right in.
It's
I apologize. Brandon Norman, Citrus County Code Compliance Officer. This is for case number 2024-01175, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for address 8245 South Kimberly Circle in Floral City, Florida. Property owner listed as Angela and Donnie B. Marcel. I have good service via posting at the property in the Lecanto Government Building. At this time, I'd like to authenticate the following documents and request to be admitted into evidence. Exhibit A will be photos taken during initial inspection on July 1st, 2024, a corrective action inspection on August 20th, 2024, and my final inspection done September 16th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, along with a copy of the photo of the notice of hearing posted at the property.
Okay, sir, I'd like to ask you to take a look at these documents, and if you do have objections, let me know. And while he's doing that, are there persons who are from the public and want to be heard on this case? Okay, thank you, ma'am. Not yet, I'll let you know. Do you have any objections to these documents?
No.
Okay. Then they'll be admitted without objection, Exhibits A and B. Did you serve in the United States Marine Corps?
Yes, sir.
When did you serve?
Ronald Reagan's there, 1982.
Well, 82. That was an interesting time to be a Marine, especially if you were in Lebanon.
Nobody messed with us while I was in there.
Yeah. Well, thank you for your service.
Beirut was the only thing that happened.
Beirut.
When they killed the, when they killed the
Oh, yeah.
Marines while they were sleeping.
That's right.
In Grenada, but that was it.
My dad was a Marine in Vietnam, and he has some interesting stories from that, but thank you for your service. All right, please proceed. Actually, sir, are you contesting whether there's a violation on the property?
No, sir.
Okay.
There is a violation.
There is a violation. All right, then let me just look through the photos real quick. I mean,
yes, on
this
the 16th.
is one of the cleaner
On the
junk
16th,
cases.
it was the first time I had met the property owner.
Okay.
So we spoke, and he's in agreement that it needs to be taken care of.
I am too.
And he's working towards it. Yesterday, I did observe some progress being made. So
Okay.
I do think his goal is compliance.
How much time do you need?
Because of health conditions right now, I have COPD and I'm on oxygen and stuff like that. I would need at least 30, maybe 60 days. Because I only can work for 2-3 hours. Then I can't breathe no more.
Well, some of this stuff looks fairly heavy.
Yes, sir, it is.
I mean, you're not doing it by
air
yourself.
Conditioning. It's all
Yeah.
air conditioning parts, and what it is I scrap the copper and the aluminum out of it, and then after I acquire a certain amount of steel, then I would take it to because you only get paid very little for the iron part, steel part of it, but the copper and the aluminum I take, it helps supplement my income.
Oh, I get it. All right, so first, and before I hear from the public, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 a day along with administrative costs to begin after the date deemed sufficient. It was selected based on the actions of the property owners that were advised, and it's appropriate given the severity of the violation. We would also ask the special master to make it the respondent's responsibility to contact Code Compliance Division once the violation's been abated so we can reinspect.
Ma'am, I'd like to welcome you up to make your input known. Take your time. If you're an ally, then you can use this podium. If you're an enemy, you have to use this podium.
Well, it depends on what's...
Oh, I don't know. So you tell me which podium.
Loves me in the morning and hates me in the
I'll tell
evening.
you.
I do. Please state your name.
Angela Marcel.
Thank you.
Well, I have news for you. You're not a member of the public. You're an owner and a party to this.
I
So
know.
you can come up and say whatever you want.
I'm pretending to be a submissive wife, and he didn't want me to come up here.
That old gambit.
Saving her legs.
Well, ma'am, I welcome your input on this.
We purchased the house in October, so it'll be a year that we've been there. It did not look like that because he was working full-time. It looks like that now because with his health, things have changed, so he needed to supplement his income. I just wanted to speak for myself that I'm not that sloppy, so.
Oh. I mean, again, we've had a lot of firsts in this hearing, and
She's a New Jersey beach girl.
that's. Well, I appreciate that input, and you haven't been able to see it. Eventually, we're going to be able to show the photos on these screens, and we're going to do that. But, well, I won't speak for the county. It's not me, but the county. My understanding is the county will be doing that. If you had, you would have seen that this is by far the least junk of any of the junk cases that
Because
we've had.
it's really not junk.
Well, it is.
It is.
I hear what you're saying, but
Okay.
this is, the rest of your yard looks very nice.
It is.
So,
It's beautiful.
So
It's my
congrats-
happy place.
yeah. All right. I am ready to issue a ruling. I am going to find that the property is in violation. I am going to grant you 60 days from today to abate the violation based on your representations that, under normal circumstances, you think a month probably, but there's issues. 60 days sounds like enough time. I mean, in looking in the amount, I really do think you can get it done in 60 days.
All the stuff that's on the slab is pretty much all gone now.
Okay.
It's just the stuff that's behind the shed.
Don't make me give less time. So if it's not brought into compliance within 60 days, a $50 fine will be assessed.
I have a question.
Yeah.
This is going to be an ongoing thing with him. He wants to do this as much as he's able. And from what the gentleman told him the other day, I've always been a city kid. I didn't know you needed permission to do stuff on your own property.
Well, guess what? This is one folder full of rules that
I
you
see
are
that.
responsible for, and that's not it. Here's a second folder full of
Thank-
rules that you are
thank you.
responsible for.
Thank
And
you
so
for making it
here's
more
what I would say.
complicated.
You have a big garage, I would use it.
No.
Well, it's up to you.
No, what I was going to ask,
Yeah.
what I was going to ask is, are we permitted to erect a fence so that it's not,
I would, so at the beginning, I gave a speech, and one of those things was, and I don't blame anyone for not listening, but one of the things I said is you really should retain legal counsel to advise you on these things. I'm not your lawyer. It's my job to preside over this stuff.
where do
But
I,
I also,
where do
ma'am,
I find the rules?
I encourage, they're online, but I encourage you to contact the county with those questions. They will tell you, I believe. Again, I'm not in charge of them, but it's my understanding that they normally do.
Okay.
All right?
Thank you.
Thank you.
Thank you.
Next case, Southern Tree Services LLC, case number 2024-1051. Case, Code Officer Alan Jonathan, page 33 of your agenda. Expert on the case, Joanna Katu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Bryce Perry.
Good morning.
Alan Jonathan, Citrus County
Oh,
Code.
and Mr. Perry, I'm sorry, Mr.
Go ahead,
Johnson.
go ahead.
Are you an owner or representative of Southern Tree Services?
Yes, I'm one of the owners.
Thank
There's
you.
the two of us. Alan Jonathan, Citrus County Code Compliance Officer. This is case number 2024-01051. Citrus County Land Development Code, Section 4002, Site Development Without a Development Order or Permit. Address of the violation is 3236 North Florida Avenue, Hernando, Florida. Property owner is Southern Tree Services, LLC. This property is 12.40 acres and is zoned industrial. I have good service via signed certified mail receipt and posting at the LaCanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 10 June 2024. Permit check compliance inspection on 22 July 2024. Aerial photos from the property appraiser's website from December of 2021, July of 2023, and May 6th of 2024. And photos from my final inspection conducted on 17 September 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the SunBiz, a copy of the signed certified mail receipt, and a copy of the pre-hearing order.
Okay, sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence. And also let me know if you're contesting whether a violation exists.
I'm not contesting it, no, sir.
Okay, all right. Is there anyone from the public who's going to want to be heard on this case? I don't see any response.
That's all the photos. Okay.
All right, so without objection, we'll just admit exhibits A and B. I'm kind of interested to see the photos because it sounds like a big parcel, also zoned industrial. But before we get to that, well, is the county asking for a fine?
Yes, sir.
Okay, let me just take a look at this. This is zoned industrial?
Mm-hmm. Yes, sir.
Wow.
Yes, sir. It's old phosphate mine.
Wow. What's the county's recommendation?
$5,000 one-time fine.
What happened here?
So I'm working on permits. I have all my engineering stuff. I have permits from DEP. I have my DOT permits for the entryway and all that. It's taken a long time.
I mean, the issue for this hearing is what they're essentially saying is that because what's occurred already is essentially irreparable, and I know you can develop it and do things with it, but they're going to request a one-time fine instead of like a daily fine and a time to comply.
Understood.
Now, previously at the hearing, the county requested a $5,000 fine, and then I gave a $2,500 fine. That's what I'm going to do again. But is there anything else you want to add?
No, sir, just that we're working on it. I have engineering and all that, so it will be permitted.
Does the county have any objection?
No, the only concern I have, and I can talk to the gentleman
Yeah.
afterwards, is just what's happening on the property.
Well, what's your concern?
Well, they're a tree service, and they're bringing in tree debris and burning it, and that's a...
It's not before me, though, is it?
No,
Yeah,
absolutely.
Okay,
I just...
all right. It's something you want to work with before
Absolutely.
it comes to me.
Absolutely.
Okay. Does that make sense?
Sounds good. Do you want
There
to-
may be another code violation, and he wants to talk to you about it?
We'll talk about it.
Yeah, I don't want to get into it. So, all right, that's what I'm going to order is a $2,500 fine, and that's it.
Thank you.
All right, thanks.
Next case, Tammy, you're going out to.
Yeah, if you don't mind.
Never mind, no problem. Next case, Shirley E. O'Brien, case number 2024-650. Code Officer Cody McGuire, page 31 of your agenda.
Let the record show Shirley O'Brien has been deceased since March 22nd of 18.
Okay, thank you.
Mayor, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Mary Hanson.
All right, Ms. Hanson.
And my dad's working his way up here. His name's
Okay.
Harold Lockard.
Harold Lockard. And are you all occupying the property? Are you heirs to Miss O'Brien?
My dad is, and I am.
Yeah.
When he goes, I'm taking care of him now.
Do you reside on the property?
We do.
Okay, all right, then you have standing. The problem with listing Miss O'Brien as the owner is it probably hasn't been changed on the property appraiser's website.
Well, the taxes come in Dad's name.
Yeah.
I pay them every year.
No, I'm telling you that the reason why the name, it's because it probably hasn't been changed on the property appraiser's website as to who owns the property. So usually they go off the last deed unless there is a death certificate recorded in the public records.
We have our death certificate.
So no, I'm just saying that I understand what you've asked the record to reflect, but in fact, the record does not reflect that with the property appraiser. So that's the issue, and I would really contact them to work that out.
Okay, because I know he did go up and try to get it straightened out.
Yeah.
The property was in her name before they got married. Then they got married, and the home's in his name.
I'm just letting you know
So-
that that's not, there's a reason why this notice is in her name.
Okay.
It's not because the county screwed up, it's because the property appraiser reflects that the last deed was with her name.
Okay.
So I would go check that out.
Okay.
Now, Mr. Lockard, have you sworn an oath to tell the truth, the whole truth, and nothing but the truth? Yes. Well, let me,
Yeah, put your right hand up there.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
And your name, please?
Harold Block.
Thank you.
Thank you, sir. And is it your understanding that you are an owner of the property?
Yes.
Okay. And you reside on the property, correct?
Yes.
All right, so what I'm going to do is I'm going to let the county to present its case, and then I'll turn to you guys. Go ahead.
All right. Cody McGuire, Citrus County Code Compliance Officer. Case number 202400650, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 6939 West Borstein Court in Crystal River. Property owner Shirley E. O'Brien. Good Service is posting on the property and posting at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on April 8th, 2024, subsequent inspection on May 5th, 2024, corrective action inspection on August 15th, and photos of my final inspection on September 17th, 2024. And Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, copy of the photo, and the notice of hearing posted on the property, and a pre-hearing order.
All right, so ma'am and sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this.
Legal. That's gone. That's gone. That's gone.
All right, ma'am, no, that's not what I'm asking. What I'm asking is, do you have any legal objection to them being evidence in this hearing?
That's gone. That's gone. That's gone.
Do you have any reason to believe those
No,
photos
sir,
are
I'm
fake?
going through the papers now.
Yeah.
That's one thing. That's no longer there.
Mr. McGuire, have you had contact with Ms. Hanson and Mr. Lockard before?
Yes.
Okay.
I've talked to Mr. McGuire one time on the phone.
No, I was asking
And he
him.
was supposed to come out and meet me, and he never showed up.
Okay.
He's also supposed to meet another friend of ours the same day because it's code enforcement on theirs, and he never showed up for theirs either. But most of the stuff is gone. I never got any of these in the beginning. I got a card from you on the door. And I
Sir, I'm sorry, ma'am. I would just direct your comments to me. The witnesses aren't supposed to argue about the evidence.
I'm not arguing, sir.
Yeah.
I was just telling Cody that when I reached out to him, I reached out to him because he left a card on
Yeah.
the door, but I had never received any of these
Gotcha. All right. How did you know to be here today?
because this was stuck in my driveway.
Okay.
Right there, just like that. That's where they were stuck.
And is there anyone from the public who wants to be heard on this case? I don't see any response.
Yeah, I guess.
All right. Do you have any objection to these documents being evidence in the hearing?
Yeah, I do.
Okay.
Most of the things are gone.
Okay.
All the vehicles, the pontoon boat, when you get the pictures, the pontoon boat is legal. I have a tag for it. The motorhomes are legal, insured, and tagged in the state of Florida.
All right, so I want you to understand that this is not an unlicensed or an inoperable vehicle case. This is a junk and debris case. So they're not claiming, there's nothing about the vehicles being unlicensed or inoperable.
Well, a lot of the junk and debris has been moved.
Okay.
I understand you were there. I understand he was there yesterday.
Mm-hmm.
If he would have came in the afternoon,
Mm-hmm.
per our conversations, he knows I work 7 to 3, 5 to 6 days a week. I run a hotel.
Mm-hmm.
I've told Cody this. And he came, if he would have came out in the afternoon, he would have seen that there's been a lot more done because I was out there working yesterday. There's only me and my father. My father had a heart attack a year ago. And a year ago this month, as a matter of fact. And was in the hospital for almost a month. So it's been a time.
Well, I'm looking at photos from April and
Most of that, all that's gone.
May, and
The red trucks are in the backyard behind privacy fence.
August, and let's see.
And then that big boat that's in the side yard, that's also in my dad's name, belongs to my little brother who just got out of prison from doing a 9-year sentence.
Are you contesting whether there's a violation on the property?
Yeah, I am.
Okay, then please proceed with your case.
Okay. On April 8th, 2024, I conducted an initial inspection and observed the property to be in violation, and notice a violation was issued for junkyard conditions, which is a violation of the ordinance listed above. A subsequent inspection was conducted on May 5th, a corrective action inspection on May 10th, and I observed the property remained in violation as of my final inspection on, As of my final inspection on September 17th, the property remained in violation. I have had contact with Ms. Hanson, and we went over on how to abate the violations.
And when was that conversation?
On May... I don't have it wrote down.
Okay. Ms. Hanson, do you remember when in May that occurred?
It was May 7th, I'm sorry.
I called and talked to him on the phone. Yes, I do.
Okay.
And I did remove the door that you asked
So
him
that
to
was
remove.
4 months ago. How much more time do you need to clean up this property?
Well, you see it. There's just me. He's not able to do anything. There's just me. So I need at least 30 to 60 more days. And
I
there's
guess
not
what I don't
much more
understand
left.
is you just testified that you were contesting that there's a violation on the property. I can
On-
see the photos.
On the debris stuff, we've had hurricanes right in Christian River. I've been
Yeah.
cleaning up. I've been trying. Every time I try to burn the trees and stuff, the neighbors call the fire department. So I'm trying my best here. I
No,
don't get
know,
off
but
work until 3
listen,
o'clock in the
I'm trying
afternoon.
I have to give you a time to comply, but on one hand, you've told me there is no violation. On the other hand, you've said you need 30 to 60 days, so I don't know which one it is.
Well, on the debris stuff that's left, yes, I need at least 30, probably at least 30 more days
So are
to
you
get that up.
withdrawing your comment that you are contesting whether a violation has occurred?
I guess I am.
All right. What's the county's recommendation?
$100 per day.
Right, I'm gonna give you, what you said 30 to 60, I'm gonna give you 45 days to bring the property into compliance. If it's not brought into compliance in 45 days, it's a $100 fine a day. I do think that's enough time based on what I see.
Well, can he go over with me what needs to be gone?
Well,
You were there yesterday.
Ma'am, please do not address him. Please address me. And I read earlier the definitions of junk and debris, and that's what you've got to do. So it just has to be, and I'll go through it just very briefly again. Here's what junk is. It's abandoned property, construction and demolition debris, litter, waste materials of any kind, used or unserviceable automobile or machinery parts, used or non-functional furniture or appliances, or used and non-functional tools, equipment, and implements. And then if we look at debris, it's material which is stored externally, exposed to the elements, and is not otherwise completely enclosed by a walled, roofed structure, and shall include but is not limited to discarded household items, inoperative machinery, appliances, refuse, rubbish, trash, junk, and rubbish is defined as combustible and non-combustible waste material other than garbage. So in looking at these photos, I see a lot of scattered debris and kind of miscellaneous, even vegetative matter, accumulations of vegetative matter, if they're like all put in a pile, if you cut a bunch of branches or something and put them in a pile, that is a part of this. Like I said, I think you can get it done. I don't see any reason why you couldn't fix all
Yeah,
this.
because the majority of the stuff's gone out of them
Yeah,
pictures.
yeah, so you've got 45 days. All right, thanks.
Thank you.
Thank you.
Next case, Tammy Quinetta Turner, case number 2024-1143, Code Officer Alan Jonason, page 35 of your agenda. Expert on the case, Joanna Katu.
What page of the agenda? I'm sorry.
35.
All right.
Do you swear to tell the truth, the whole truth, and nothing
Yes, ma'am.
Please state your name.
Tammy Quinetta Turner.
Thank
Good
you.
morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-01143, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102. Address of the violation is 1628 East Derby Drive, Citrus Springs, Florida. Property owner is Turner Tammy Quinetta. This property is .35 acres and is zoned Planned Development Residential.
How
or
many
PDR.
acres?
.35.
0.35.
I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 24 June 2024, photos from my compliance inspection on 25 July 2024, and photos from my final inspection conducted on 17 September 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavit.
Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence. And also let me know if you're contesting whether there's a violation. Is there anyone from the public who wants to be heard on this case? Right, I don't see any response. Ma'am, are you contesting whether there's a violation on the property?
No, sir.
No? Okay. Then we'll get to that. Any objection to these documents?
No, sir.
All right, then exhibits A and B are admitted as evidence. Thanks. So, Mr. Jonason, she's not contesting that a violation has occurred on the property. Can you tell me just briefly what the violation is?
So the violation is storage on a vacant. She's
Storage on a
storing items on a vacant property.
And so what has to happen is either those items get removed or she establishes a principal use.
Structure. Yes, sir.
Does that make sense?
Yes, sir. Can I expound on what's going on?
Yeah.
Okay, so I'm in the process of building on the land, and I went into this not understanding how it works. So when I purchased the land, and I had did some inquiring about what I could do with the land. So I'm going to be building a cabin on there.
Okay.
And but I'm doing an owner-builder thing. So I was told that I could live in my trailer for up to a year while I'm building. But I didn't realize at the time I had to pay an $8,000 impact fee, and I have $6,000 of that already paid, and I owe $2,000 more.
You've already paid $6,000 of an $8,000 impact fee?
Yes.
Is there an $8,000 impact fee for residential construction on this?
No, I think she might be talking about utility connections, water, central water. No, you don't prepay impact fees. We don't have a
I've never heard
partial
of that.
pay or yeah, that's not an option. I couldn't find any permits for this site.
Okay. Do you know what you paid?
Well, like I said, I'm doing an owner-builder.
Right.
And I was told that before you could get a permit in hand, you had to pay impact fees. So the impact fees, they told me was $8,000. And then
And when you say they, who is they?
here, I came here.
The
I
county
came
told
here
you.
like 5 times trying to make sure that I was told the correct thing. And I talked to one young lady, and
Do
she
you know
told-
her name?
I'm not sure
Okay.
her name. So then I was told that I had to have engineering documents, seals, wet seals, for the construction before I can actually get the application for the permit. So I've been trying to get, and that cost me, that's going to cost me $2,700 just to get the wet seals. So I've been trying to get all of this stuff paid to get the permit in hand so that I can be able to have
So that you can stay in the trailer
Yes,
while
sir.
construction goes on.
Yes, sir.
Ms. Katu, I would like to, if possible, just make sure I understand. Are you able to translate your understanding of the process of how it works?
Yeah, so once you have a permit in hand, you don't prepay fees or anything. Hopefully you didn't pay anybody, because we wouldn't take money for that. Once you apply for a permit and you pay the application fee, that includes an impact fee. And at the time, once your permit is issued, you can ask to stay in an RV while you have an active building permit. Now, if she's found guilty today, she will not be eligible for that regardless. That's
Really?
something that the commissioners have pushed down to us, that if you're in violation of that already, you jump the gun, you can't get that approval. It's a tentative thing. It's not automatic approval for the RV.
Meaning it's not automatic if there was no violation, but it is an automatic denial if there's a violation and then an application comes for it.
Correct.
How much does a permit cost for something like this?
The impact fees are about $7,700. I think I'm right on that. Off the top of my head.
So her numbers sound about right.
For impact fees, but you
Right.
don't prepay it. It's part of a larger impact fee, a permit fee, and the permit fee's probably gonna be more than that. The engineering she's talking about, it sounds like she's maybe saving the money up to apply. But
Do you have any idea where you paid that money?
The check was sent here to this facility.
And they deposited it.
They're holding it
Oh.
until I finish paying the rest.
So they have not deposited any money for you.
Well, I'm not sure. I just know it's on record here, because I called and they said they do have it on record. But they said I had to get the engineering docs, wet seals turned in first before I even can put the application in. They said, don't even try to put the application in until you have the wet seals in hand.
Well, normally, wouldn't that be a part of the application?
right, there's not a mechanism to accept a check up front.
Do you
so
know
I'm
if the
not-
county has ever accepted a check as like a deposit and then not deposited it or just held it in escrow?
Not for a building
I don't think your
permit.
county attorneys would let you do
Yeah,
that.
we don't even have a process for that. I
Okay.
couldn't even find an application for this permit, even an open, unfinished application.
Okay.
So, I don't know what this is.
I mean, Ms. Turner, I'm concerned by what's been represented because I don't know if you paid someone else or sent it to a different address, or that's a lot of money to just be sitting somewhere.
No, I got, the money was sent through a grant program, and I've been talking to a lady named Miss Shannon, and she's been like guiding me on everything. And like I said, the last time I literally came here, like I said, 5 times, trying to do everything the right way.
ship kind of
And
thing.
when I brought the application here, filled out and tried to turn it in, I was told I couldn't turn it in until I had the wet seals in my hand to turn in with the application. And I'm trying to get that done and pay for that. But it's hard because I'm a single mom and I'm trying to do all this out of pocket. And so that's why it's taking me so long.
Do you all know who Miss Shannon is?
Yeah, she is one of the permit specialists in building division, but once some of the words she said made all of us go, oh, we think we know what she's talking
Okay.
about. There's a process through the housing division to help to provide assistance for income levels to help you with a permit, and that's probably who she's working with. That may be somebody that's holding a check for her and trying to help her through the process. That could be, she could be doing that.
Wow, if you guys are holding checks,
Yeah, we
that's
don't.
really...
I'm not aware of us ever holding checks. I'm going to have to
But
go back
okay,
and
but
find
you're aware
out.
of what
but-
she's talking about now based on the name.
Yeah, I don't know about the check part, but
Okay,
yes,
okay.
the way she talked when she said a grant, that was, oh, okay, well, she's
Would that-
probably working for somebody
Would that
else.
affect her application to live in the trailer based on the owner-builder? I mean,
No, it would have no.
well, what I'm getting at is, would the county automatically deny that application based on the fact that it's going through this program?
No, not at all, not at all. Low
So you think
income
this is something y'all would look at?
It's absolutely, it's like any other application. They're just providing a reduction in some fees and maybe some assistance with the permit process.
Well, what I'm getting at is, if she moves along the process and manages to get an application in and then applies to live in the trailer, is it your representation that it would not be an automatic denial? Do you know if it'd be an automatic denial?
Right, the only automatic denial would be if today she's found guilty for already living in the RV ahead of time.
And that's regardless of whether it goes through this grant program or
Right,
not?
it has
Okay,
no,
that's what I
no
was
impact.
wondering.
I'm just be a little more assured. I think she might be talking to somebody outside of building and working on that.
And today's hearing isn't about living in an RV. It's
No.
about storage.
Right, it's for
not
storage,
living.
correct.
Okay,
As
all
far
right.
as I'm aware, it's not living.
Okay, all right. So, Ms. Turner, I guess do you have any idea how long it'll take you to work through this process to try and get a permit, or do you know?
Honestly, like I said, the way my income is right now, I'm trying my best to do it as fast as I can, but I need as much time as that you can allow me.
And it's your understanding that you still owe $2,000 more on the impact, let's call it the impact fee stuff.
Yes, sir.
And then you still have to get $2,700 for the wet seal
Yes, sir.
plans, that kind of thing. And it's your understanding that's a precondition just to even applying
Yes,
to
sir.
have the trailer on the property. All right, I think I understand now.
Can I
Mr. Jones?
also,
Yeah.
Can I also add, we had a previous case, I think it was back in May, for the same property. I don't know if you remember, it was a site mod where.
I do remember.
Okay, all right, I just wanted to, we talked about the items that I was gonna be bringing this case at that time. Just wanted to put that out there.
No, I do have a recollection. Let me just look at the photos. What's the county asking me to do?
$100 per day.
Okay. What I'm going to do, Ms. Turner, is I'm going to do my best to give a reasonable amount of time. And I think what the county's also saying is, look, this has been pending for a while. You know, there's other cases. This isn't something that came out of the blue, and I understand the circumstances. So what I'm going to do is, based on the representations, I think it's accurate. It sounds like you've contributed a lot already. You're kind of down the line on this. I'm going to give 90 days to bring the property in compliance. So you have 90 days to either get everything off or find a way to allow you to stay there through the permit process. Does that make sense?
Yes, sir.
All right. So if it's not brought into compliance after 90 days, Mr. Trump. Oh, okay. Then there'll be a fine of $100 a day.
Okay, thank you.
Good luck.
Thank you.
Next case on today's agenda, Naughty Time LLC, case number 2024-982, Code Officer Julie Wilkinson, page 30 of your agenda. Expert on the case, Joanna Katu.
Now, Naughty Time has appeared before me before, correct?
Yes, sir.
Okay, that's a good name. That's why I remember. All right.
Do you swear to tell the truth, ma'am?
Yes.
Do you
Say
swear
the
to tell
truth,
the truth,
yeah.
the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your names?
My name is Marielis Davila.
Can you spell the last name?
Davila, I think.
Davida?
Davila.
Davida. Davila.
Davila.
Yeah, okay, thank you.
Thank you.
And my name is Marguerite Hires, Hiers.
And are you representatives of Naughty Time LLC?
I'm the owner.
You're the owner? Okay, all right, great.
I am a friend.
She helped me with my English.
Okay.
I'm getting her right here.
Okay. But you understand my words?
Yeah, I'm a little
Entiendes mis
nervous, but-
palabras?
Yes.
Y, okay. All right, then please proceed.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2400982, Land Development Code, Section 4100, Site Improvement Plans. The address is 10317 West Yulee Drive in Homosassa. The property owner is Naughty Time LLC. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on May 24th, 2024. Photos taken during a corrective action inspection on August 1st, 2024. And photos from my final inspection conducted on September 17th, 2024. as well as a copy of the 2016 site plan for building permit number 201611019. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photos of the notice of hearing posted at the property, and a copy of the posting affidavit.
Can you summarize for me, Ms. Wilkinson, what the nature of the violation is?
Yes, so this property has on-site dining, seating and outdoor seating, which was not approved on its original site plan, in its original permit.
I see. So they have a site plan on file, they received a permit, but they've put other things on the site that are not approved under the permit.
Yes.
And is this, to your understanding, I say this so that we're all on the same page when you show them these exhibits. Is this a restaurant or?
Yes, it's a restaurant.
That's my recollection, okay. All right, so ma'am, I'd like you to take a look at these photos and documents and let me know if you have any objections to them.
No, it's correct.
Okay,
It's true.
all right.
This is together? This is yours too?
Which are the things I don't understand to help her understand? Which are the things?
Well, ma'am, here's the issue is, these are documents that are proposed evidence in this hearing. So there's photos and there's a notice of a hearing, notice of a violation. I understand, technically you don't have standing to, you know, I'm letting you, you know, I want you to be there, but she seems to understand. I mean, she didn't say there were any problems, so.
No, it is true.
Yeah.
I did that because I have a carport.
Yeah.
I have 4 tables.
Mhm.
Sometimes one person coming and take the whole table for themselves.
Mhm.
And then I have customer that they smoke
Mhm.
and I have a carport. And sometimes I have babies, pregnant women, people don't smoke. And they start to smoking with the carport.
Ah,
And I put a 3 picnic table that people smoke.
okay. Well, so let me just look through this really quickly. Let me take a look. I am familiar with the property. So it appears on the file copy of the site plan. I assume this is the site plan,
Yes,
Ms.
sir.
Wilkinson? There's, in all capital letters, "No outdoor seating!" exclamation mark. You don't normally see those exclamation marks, but let me just look through this. Just gonna look up the code section real quick. Did you know I was going to do that?
No.
Oh, okay. I heard laughter, I don't know.
Oh, that was Jason's being.
Okay. Section 4100. I think this is the recent July 12, 2022 copy. A site improvement plan shall be required for any development proposed on improved land. Okay, so the original notice of violation here was sent on in July. Did you understand at the time what the county's problem was?
That in this time, was my husband taking care of
Okay.
the situation, but he's out of town. Then I received this in front of my property.
Mhm.
The reason I'm here.
Okay. Have you had any contact with Ms. Wilkinson about this?
No, with her. My
Okay.
husband. John Lecliner.
Listen, I'll tell you what, her English is a lot better than my Spanish. She
Right.
seems to
She was very
understand.
nervous on
Yeah. Right, no, it's okay. Okay.
What I go to do the solution? The people to smoke. What I go to do? Buy another table or?
That's not really, so that's not the immediate problem. The immediate problem under the county is that you have developed the property in a way that the site plan doesn't allow. So I'll let the county speak for itself. Would they be able to seek an amendment of the plan? Not knowing whether it'd be approved, but is that what they'd have to do?
I'll defer to my expert,
Yeah.
Joanna Catu, Land Development Director.
Technically, yes. The problem with this site is because it's so narrow with these two roads, that's why previous owners, that's their writing to take out only with the explanation, because it's very hard to find parking adequate to room for parking to try to fit these seats. So it was take out only.
So you're saying is it a capacity problem?
I think so. I think we can certainly work with them and try to get as many seats as we can. We try to get the parking. I see some overflow on there that they might have to pave then, and that's a problem too because that brings in stormwater. It's a bit of a snowball, which is why previous owners kept with takeout because it's so constrained. It's
Could
not
they
that-
so they could abate the violation by removing the seating?
by removing the seating, right? And then they can talk with permitting about future plans or to try to do outdoor.
So here's the deal. There's two ways to fix this. One is to remove the outdoor seating because it's not allowed under the site plan. And so if you do want to have some of that seating to address the problems you're talking about, then it would be important to seek an amendment of the site plan, and you would work with the county on that. They're not under an obligation to just approve anything. What Ms. Catu testified to is that there may be ways to work something out,
Mhm.
okay? It might involve establishing some paving, it might require some more parking, I don't know. That's not the purpose of this hearing, but does that make sense?
Yeah.
So what I'd be doing is giving you an amount of time to either remove all that stuff or seek an
Or
amendment.
the amendment, yeah.
Correct. I honestly don't think it would take you much time to remove the seating.
No.
Yeah. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay. So essentially what they're asking is to make sure that you are in touch with the county once you fixed this. I am going to grant 30 days to abate the violation. If a violation is not brought into compliance as ordered, a $100 a day fine will accrue. Now, is there anyone from the public who wants to be heard on this case? I don't see anybody. Okay.
I have one question.
Yeah, go ahead.
Okay, the violation is the 3 picnic tables?
How many?
All of the outdoor seating, all the picnic tables in the shaded carport and outside on the cement patio.
Well, the carport is allowed under the
Yeah,
site plan.
It's allowed.
I know, but
The table's under the carport.
we have to be clear,
Oh.
especially because there's a language issue. So it's the seating. You're allowed to have the metal carport. That is allowed under the site plan. But all the outdoor seating,
But at the beginning, they said me yes when I opened.
not under your site plan. I mean, when did they tell you yes?
Before I opened the restaurant,
When was that?
4 years ago.
Who is they?
I was here with like 6 or 7 people. They said me what I need to do with my restaurant.
So 4 years ago, before this opened, you came to the county
Yes, I came here
and
with my husband.
you were sitting at a table with 6 or 7 people.
Yes,
And you asked if you could have outdoor seating,
yes,
and they said yes.
yes. The problem, under the carport,
Do you
yes.
remember who that was?
4 years ago, and my
Yeah.
English, no.
Let me just look at this.
I can be takeout only because like I do hot wings. I can have people 10 minutes waiting in the parking lot.
Mm-hmm. Well, there isn't much parking here. Let me see.
She may be referring to the seating allowance that the health department gave her, but that's separate from us.
Meaning that they allowed a certain capacity.
Yeah,
Yes, for the
16
for the
people.
septic system that's on site.
Okay, so here's basically one hand didn't necessarily know what the other hand was saying, but they're separate issues. One is that you may have a capacity that would allow you to have other seats,
16
regardless of
people,
where they are.
yeah.
Right. But the problem is you still need to have an approved site plan with that seating. You do not. That's the issue. So that's the seats that are under the carport. That's what I'm telling you. You have to get the site plan changed. You have to amend it and work with the county on doing this.
I can go tonight to my email and check my 4 years ago with the history of emails back
I
and
don't
forth.
have the email before me, and the county's saying that they're sticking by the site plan. And the site plan clearly says no outdoor seating. It even points to the carport. It points to the carport. So it's a violation of the site plan right now. You have to change it with the county. So I'm gonna give you 30 days to either remove it or to get it allowed.
Allowed, yeah.
Okay?
I need it.
Right, I agree. So that's how it's gonna work.
Okay,
All
30
right?
days.
All right,
Yeah,
buena
thank you.
suerte.
You too.
Talk to the county.
Thank you.
Next case, James L. and Karen E. Serber, case number 2024-609, Code Officer Julie Wilkinson, page 34 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
I'm ready.
Julie Wilkinson, Citrus County Code Compliance Officer. Case number 2400609, fences, hedges, and walls, a violation of section 3150B of the Citrus County Land Development Code. The address is 5600 South Oak Ridge Drive in Homosassa, Florida. The property owner is James L. and Karen Serber. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on April 1, 2024. Photos from our corrective action inspection on July 24th, 2024. And photos from my final inspection conducted on September 17th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the posting affidavit, and a copy of the notice of hearing posted at the property.
Is there anyone from the public who wants to be heard in this case? Okay. Without objection, exhibits A and B are admitted in evidence. Thank you.
On April 1st, 2024, I conducted an initial inspection and observed a privacy fence on the property. The property is 1.67 acres and zoned CLRMH, coastal and lakes residential. Portions of the fence were constructed of aluminum sheet metal, which is not an approved fencing material. On April 2nd, 2024, a notice of violation was issued for fences, hedges, and walls, which is a violation of Citrus County Land Development Code. On July 24th, 2024, I conducted a corrective action inspection and found that the fence remains in violation. I have had contact with the property owner, Ms. Serber, who has told me that she's hired someone to fix the fence. As of my final inspection on September 17th, the fence remains in violation.
What's the county's recommendation?
$100 per day.
The property is found in violation. The owner is granted, when did your investigation start?
On April 1st.
15 days to bring the property into compliance. If it's not brought into compliance, $100 a day.
Thank you.
Thanks.
Next case, David A. Bratsky, case number 2024-1086. Code Officer Julie Wilkinson, page 7 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Julie Wilkinson, Citrus County Code Compliance Officer, case number C24011086, home occupations in residential districts, a violation of Citrus County Land Development Code 3190. The address is 6950 West Sedate Court, Homosassa. The property owner is David A. Bratsky. I have good service via posting the notice of hearing at the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on June 11th, 2024, photos taken during a corrective action inspection on July 30th, 2024, and photos from my final inspection conducted on September 17th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the notice of hearing posted at the property, and a copy of the posting affidavit.
Is there anyone from the public who wants to be heard on this case? All right. Without objection, what's been proposed as Exhibits A and B are evidence. Please proceed.
On June 11th, 2024, I conducted an initial inspection and observed the property had signs in the front yard advertising that there was a tire shop there and it was open. There were racks of tires on display in the carport and in the canvas sheds. I made contact with Tiffany, who stated that it was a hobby. I informed her that I had found pages on the internet advertising that location as a tire business, and the signs out front also advertised the location as a tire shop. I advised her that the signs advertising the business needed to be removed. The property is 1 acre and zoned rural residential mobile home. On July 11th, 2024, a notice of violation was issued for home occupations in residential districts, which is a violation of the Citrus County Land Development Code. On July 30th, 2024, a corrective action inspection was conducted, and I observed that some of the signs were taken down, but a large sign in the carport advertising the tire shop remained. As of my final inspection on September 17, 2024, the property remained in violation. I have an expert on the case, Land Development Director Joanna Katu.
I don't know if you need to hear from me or.
Well, I guess one thing I'm just curious about is how does this work with that Florida statute that talks about, is there any reason to believe that there's a conflict to the best of your knowledge? Do you know what I'm talking about?
I recall that coming up before.
Yes.
No, there's not a conflict. This is clearly viewable from the street. You can see that it's a business that they're operating, and that would be in violation of that at-home business statute. That
I agree, but I guess what I'm really asking is, I'm not arguing that there's a way out under the statute. I agree that it would violate even under the Florida statute. What I'm curious about is everything in LDC 3190, is anything in LDC 3190 exempted by the Florida statute? Do you know? Or preempted by the statute, to the best of your knowledge?
The statute you're referencing may preempt this.
Okay.
But it's very limited. That statute limits it to what type of business, how they run it, how it operates. So during their investigation, if they get an investigation for this, they would then look at the statute and say if it.
I know it violates the statute. My concern is just looking at how 3190 relates to it. And so I think that's interesting. My suspicion is some of it is preempted, so that's just, but I do think there's a violation. All right.
I appreciate that.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative costs beginning after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We'd also ask the special master additionally to find that it is respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
There's a violation. I'll grant 15 days and $100 a day if it's not brought into compliance as ordered.
Thank you.
Next case, Harold Miller and Lucy Reed, case number 2024-906, Code Officer Allen
And
Jones.
I'm sorry, Mr. Tron,
Go ahead.
I just thought of
No, no.
something. What I want to make clear is there's a violation to the extent that there's a violation that is not exempted under the statute. Okay?
Yes.
Thanks.
Next case, Harold Miller and Lucy Reed, case number 2024-906, Code Officer Allen Jonathan, page 28 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-00906, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 2630 East Mercury Street, Inverness, Florida. Property owner is Miller Harold, attention Lucy Reed. This property is .46 acres and is zoned MDR-MH. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 22 May 2024, compliance inspection on 15 July 2024, and photos from my final inspection on 17 September 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, copy of the signed certified mail receipt, and a copy of the pre-hearing order.
Okay. Is there anyone from the public? Nope. I'm going to stop asking that. Exhibits A and B are evidence.
On 24 May 2024, I conducted my initial inspection and observed the property to be in violation. On 22 May 2024, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance mentioned earlier. On 15 July 2024, I conducted a compliance inspection and observed that the property remained in violation. I have had brief contact with the property owner, and as of my final inspection on 17 September 2024, the property remains in violation.
What's your recommendation?
$100 per day.
All right. I'm going to grant 15 days and $100 a day.
Thank you.
Yep.
Next case, Christopher Nash, case number 2024-1156, Code Officer Allen Jonason, page 29 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer, case number 2024-01156, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. The address is 1740 North Troy Loop, Inverness, Florida. Property owner is Nash Christopher. This property is .30 acres and is zoned MDR-MH. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 26 June 2024, photos from a compliance inspection on 29 July 2024, and photos of my final inspection conducted on 17 September 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavit.
Exhibits A and B are evidence. And did you take these photos on the dates indicated on
Yes,
the
sir.
photos?
Yes, sir.
And these are accurate representations of the property?
Yes, sir.
What is the county's recommendation?
$100 per day.
10 days, $100 a day.
Thank you.
Next case, Alexander P. Uvisic, case number 2024-1329, Code Officer Julie Wilkinson, page 36 of your agenda.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2401329, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 5189 South Nob Hill Terrace in Homosassa. The property owner is Alexander U. Uvacek. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during initial inspection on July 25th, 2024. Photos from a corrective action inspection on August 9th, 2024. And photos from a final inspection on September 17th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right, what's been proposed as Exhibits A and B as evidence?
On July 25th, 2024, an initial inspection was conducted and I observed loose trash, appliances, furniture, miscellaneous junk and debris on the property. I made contact with the property owner, Mr. Uvacek, and advised him of the violation, and he stated that he would get it cleaned up in the next few days. On July 25th, 2024, a notice of violation was issued for accumulation of junk and debris, which is a violation of Citrus County Code of Ordinances. On August 9th, 2024, I conducted a corrective action inspection and observed that the property remained in violation. As of my final inspection on September 17, 2024, the property remains in violation.
What's the county's recommendation?
$100 a day.
I think just so you know, you've probably noticed some shorter times to comply in this hearing, and that's because based on how long your cases are going on, I mean, they've already had 30 days, they've already had 60 days. So unless there's a good reason or a defense, even on a case like this, frankly, I'm going to grant 15 days, and it'll be $100 a day.
Thank you.
Next case, Donna J. Vick, case number 2024-01179, Code Officer Cody McGuire, page 38 of your agenda.
Cody McGuire, Citrus County Code Compliance Officer, case number 2024-1179, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 5778 West Tyriana Lane, Denellen, Florida. Property owner is Donna J. Vick. Good service posting the property and posting at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on July 1st, corrective action inspection on August 15th, and my final inspection on September 17th. Exhibit B is a copy of the notice of violation, copy of notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property in a pre-hearing order.
What's been proposed as Exhibits A and B is evidence. Please proceed.
On July 1st, 2024, I conducted an initial inspection and observed the property to be in violation. A notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On August 15th, I conducted a corrective action inspection and observed the property remained in violation. I've had no contact with the property owners, and as of my final inspection on September 17th, the property remains in violation.
Do you know if the property is occupied or not?
I don't know. I know lights are on in the house.
Oh, are they?
Mm-hmm.
What's the county's recommendation?
$200 a day.
Okay, 15 days and $200 a day if not brought into compliance.
Thank you.
Thanks.
Next three cases on the agenda. George H. Wainwright, Jr., case numbers 2024-01300, 2024-01301, and 2024-01352, pages 39, 40, and 41 of your agenda.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 2401352, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Case number 2401301, abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. In case number 2401300, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances.
This is what I consider the holy trinity of basic code enforcement nuisance cases. This is all they used to be when I started. It was just these three. Very interesting. So we got the Trinity. That's all you have to say.
Yeah,
Trinity.
the Trinity.
All right.
Or the hat trick.
Yeah. Yep.
The address is 3926 South Cedar Terrace, Homosassa, Florida. Property owner is George H. Wainwright Jr. I have good service via posting the notices of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken during an initial inspection on July 23rd, 2024. Photos from a corrective action inspection on August 9th, 2024. And photos from a final inspection on September 17th, 2024. Exhibit B, a copy of the notices of violation, a copy of the notices of hearing, a copy of the general pre-hearing order, photo of the notices of hearing posted at the property, and a copy of the posting affidavit.
Exhibits A and B are admitted as evidence in all three of the Wainwright cases. Go ahead.
Yes, sir. On July 23rd, 2024, I conducted an initial inspection and observed the lawn and weeds were overgrown in excess of 18 inches. I also observed an unlicensed RV on the property, as well as discarded furniture, appliances, loose trash, auto parts, construction material, household items, miscellaneous junk debris on the property. On July 24th, 2024, a notice of violation was issued for excessive growth and accumulation of vegetation, abandoned, unserviceable, and unlicensed vehicles, and accumulation of junk and debris, which are all violations of Citrus County Code of Ordinances. On August 9th, 2024, I conducted a corrective action inspection, observed the property remained in violation. As of my final inspection on September 17th, 2024, the property remains in violation. I have not had contact with the property owner.
What's the county's recommendation?
$100 per day.
In every case, I will grant 30 days to bring the property into compliance. To the extent that it is not brought into compliance in any case, a $100 a day fine will accrue. Thank you.
Next case, Nahad Y.
Thank you.
Abdel Aziz. Case number 2024-1205. Code Officer Julie Wilkinson, page 5 of your agenda.
Julie Wilkinson, Citrus County Code Compliance Officer. Case number 2401205, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. The address is 6943 South Sorrel Avenue in Homosassa. The property owner is Nahad Y. Abdelaziz. I have good service via posting the notice of hearing at the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on July 8th, 2024. Photos from a corrective action inspection on July 24th, 2024. And photos from a final inspection conducted on September 17th, 2024. Exhibit B, copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the notice of hearing posted at the property, and a copy of the posting affidavit.
Exhibits A and B are evidence. Did you take the photos on the dates indicated on these photos?
Yes, sir.
And these are photos of 6943 South Sorrel Ave?
Yes, sir.
All right, what's the county's recommendation?
$100 per day.
All right, I find the evidence sufficient to determine a violation has occurred. I'll grant 15 days for Mr. Abdelaziz and $100 a day.
Thank you.
Next case, Samantha Lynn Albury and Frank Alcario Jr., case number 2024-1078, Code Officer Alan Jonason, page 6 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-01078, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 4590 North Winchester Terrace, Hernando, Florida. Property owner is Albury Samantha Lynn and Cairo Frank Al Jr. This property is .57 acres and is zoned MDR-MH. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 17 June 2024, compliance inspection on 22 July 2024, and photos from my final inspection on 17 September 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavit.
Exhibits A and B are admitted in evidence. Thank you.
I would just, on 17 June 2024, I conducted my initial inspection and observed the property to be in violation. On 17 June 2024, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance mentioned earlier. On 22 July 2024, I conducted a compliance and inspection and observed that the property remained in violation. I have had contact with the property owner, and as of my final inspection on 17 September 2024, the property remains in violation.
What did the owner say?
So I spoke to the owner on 18 June. Property owner was belligerent, called me an asshole, and then hung up the phone on me when I explained the violation. And then on 26 August, the property owner was also belligerent to Code Director J.C. Charlton, and the phone call was ended at that time.
You were
as well.
present at the time of that phone call?
I was not, but
Okay.
J.C. told me about it. He put a log note into the system, and then I spoke to a woman that said she was the property owner. After that, she was very receptive, said, "What do I need to do?" And then nothing happened.
Mr. Charlton, would you mind telling me a little bit?
I spoke to the complainant. The complainant was one that was rude to me.
The complainant?
Yeah.
What problem
Sorry
did the
about that.
complainant have?
He wanted faster compliance.
I
He
see.
just wanted to know.
Okay. I mean, and so I think I see. So what is the basis for the violation as of today?
So there's, what she explained to me on the phone was the wood that's leaning up against the tree, that's the bed to a truck or a trailer. I'm not for sure, I can't tell, it's just, to me, it appears as plywood, but it's leaned up against. And then there was other junk and debris that were in the back of the property, as well as there is a table out front, some sort of handmade table or something like that out front, and then there's a door in the entryway that you can see there as well.
Yeah, I agree about the door. I see the wood. The table, I'm a little worried about because it looks like it could be like I don't know. I just can't tell.
Sure.
Like it could be a workbench or a kid bench or something
I
like
think
that.
she told me it was a raised garden, but that she didn't have anything planted in it.
All right, I am going to find that there's a violation based on the wood, whether it's a part of a trailer or not, as well as the what was the other? Oh, the door for sure. There's something behind the truck. What's behind the truck?
That, I cannot tell what it is. It just, as you can see from the photos, it kind of progresses. Stuff is there and then it's gone, and then it's there and then it's gone. It just looks like junk and debris. I cannot determine what it is.
I can't tell what it is.
Yeah, but I mean, it's not something that should be sitting outside. I mean, as far as I can tell, it looks like maybe a trash bag or something on its side. I'm not for sure.
It looks like a broken playground or something.
It could be.
I'm not going to find that the bench is a violation. I will put the broken equipment behind the truck in there.
Okay.
And what's the county's recommendation?
$150 per day.
All right, I'll grant 15 days, and it'll be $150 a day if not brought into compliance as ordered.
Thank you.
Now, we do have someone from the public come, I don't know. Sir, are you here to be heard on any of the cases?
Here for 1 o'clock, sir.
1 o'clock, wow. And what's your name, sir?
Kevin Lonzo, I'm the attorney.
You're an attorney. Okay, great. All right, so I will then go back to asking if there's someone from the public who wants to be heard on the cases since someone showed up. All right, ready for the next case.
All right.
Can I put a blanket statement out that I have nothing to say to the law?
Yeah, that would work for me.
I'll say that. I have no statements towards anything.
Very good.
Next case, Michael R. Brichtwig, case number 2024-10363, Code Officer Cody McGuire, page 8 of your agenda.
Amazingly, y'all are perhaps going to hit the 12 o'clock deadline, but we'll see.
Don't jinx us. Don't jinx us. Come on.
We'll see.
Cody McGuire, Citrus County Code Compliance Officer, case number 2024-1363, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 620-61 of the Citrus County Code of Ordinances. Address is 8998 North Amboy Drive, Denone, Florida. Property owner is Michael R. Brichtwig. Good service via posting the notice of hearing on the property and posting at the Canton Government Building. I'd like to authenticate the following documents and request they be admitted in evidence. Exhibit A, photos taken during initial inspection on July 25th, corrective action inspection on August 8th, and my final inspection on October 15th, 2024, and September, I'm sorry.
Okay.
Exhibit B is a copy of the notice violation, copy of the notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property and a pre-hearing order.
Okay. Without objection, what's been proposed as Exhibits A and B are evidence. Are the photos in Exhibit A taken on the dates indicated? Yes. Are they photos taken of 8998 North Amboy Drive?
89, yes, sir.
What's the county's recommendation?
The county's recommendation is $100 per day.
All right, there is evidence sufficient to determine that a violation has occurred. I'll grant 15 days, and the county's recommendation was 100 or 150?
100.
Okay, it'll be $100 a day if not brought into compliance as ordered.
Thank you.
Next case, C1 Property Group LLC, case number 2024-1297, Code Officer Brandon Norman, page 9 of your agenda.
Good morning, Brandon Norman, Citrus County Code Compliance Officer. This is for case 2024-01297, accumulation of junk and debris. This is going to be a repeat violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This repeat was initially observed on, I have it as July 24th of 2024. The address is 102 South Jefferson Street in Beverly Hills, Florida, 34465. Property owner listed as C1 Property Group LLC. I have good service via posting at the property in the Lecanto Government Building, and I'd like to authenticate the following documents requested be admitted to evidence. Exhibit A will be photos taken during inspections on July 24th, 2024, August 2nd, 6th, 13th, 23rd, 28th, and 30th of 2024, as well as photos taken at a pre-hearing inspection done on September 17th, 2024. Exhibit B will be a copy of the notice of hearing for a repeat violation, a copy of the posting affidavit that I completed, and photos of the posted notice of hearing for a repeat violation at the property. And Exhibit C will be a copy of the findings of fact and order acknowledging compliance from previous case for the property owner, and it's case number 267269.
All right, Exhibits A, B, and C are admitted as evidence. Thank you. Let me just take a look real quick.
Certainly. It's essentially on the right side of the home. Their trash is always overflowing, and there's a bunch of tree debris and stuff on the backside that's viewable from the street.
Okay. So the prior case was 4.5 years ago.
Mm-hmm. It was for
but did come before me, actually.
Mm-hmm. It was for a different property, but same property owner.
I see.
I've had no contact with the property owners, but I've had contact with the tenants, and they're.
You had contact with the tenants? What did they say?
They told me to kick rocks, so.
Okay. How old are the tenants?
I didn't get their ages. I'd have to say they're about my age, though.
And they said kick rocks?
They didn't say specifically.
What did they
kick rocks.
say?
There was some expletives used at a couple of inspections, and then some slamming of doors. So I don't recall exactly what words were used. It just wasn't a pleasant experience.
Mr. Lonzo, I like specifics. I mean, kick rocks doesn't cut it. So let's see here.
I'm trying to make that 12 o'clock deadline.
I know, but you had to bring a repeat case. So.
And you thought the jinx was a joke, see?
Yeah. All right. Yeah, you know, the evidence is pretty clear. So you took these photos on the dates indicated?
I did, yes, sir.
What's the county's recommendation?
We recommend a fine of $150 a day along with administrative cost to begin. At the date of the posting of the property, which was, I posted it on August 2nd of 2024, and continue until September 18th, 2024. That would be a total of 47 days at a rate of $150 per day, totaling $7,050. We'd also ask that you impose a fine of $200 per day from this day forward until the violation is abated, and make it the respondent's responsibility to contact us once the violation's been abated so we can reinspect.
What was the amount going forward?
$200 a day, sorry.
No, you did say that.
Should be September 17th.
I thought that's what I said, September 17th.
You said the 16th.
Oh.
It's okay.
I apologize.
It's just tough that, I mean, it's a tenant, you know, but I do understand what the code says. All right, I will find that a violation has occurred, that it is a repeat violation based on Exhibit C. I will assess a $100 a day fine from July, or actually, you said August 2nd, correct?
$150 from August 2nd
Right,
until
from August
September
2nd
17th.
until yesterday, and it'll be $200 from today's date until the violation is abated. Okay?
Thank you.
Thanks.
Next case, Crystal Green and Damon Luber, case number 2024. Oh, I missed one. I'm sorry. Case number 2024-1242, Code Officer Alan Jonasson.
Are you skipping Cameron?
Yeah, I accidentally skipped.
Oh, okay.
We're
No
going
big deal.
back to it.
That's fine. All right.
That happens all the time. Alan Jonasson, Citrus County Code Compliance Officer. This is case number 202401242, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6781 East Turner Camp Road, Inverness, Florida. Property owner is Green Crystal and Luber Damon. This property is .22 acres and is zoned CLR-MH. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 10 July 2024, compliance inspection on 12 August 2024, and photos from my final inspection on 17 September 2024. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavit.
Without objection, what's been proposed as Exhibits A and B are evidence.
On 10 July 2024, I conducted my initial inspection and observed the property to be in violation. On 10 July 2024, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance mentioned earlier. On 12 August 2024, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 17 September 2024, the property remains in violation.
What's the county's recommendation?
$150 a day.
All right, I'll grant 15 days, and if it's not brought into compliance as ordered, $150 a day.
Thank you.
Last case, Theodore Cameron, case number 2024-1116, Code Officer Alan Jonasson, page 10 of your agenda.
Alan Jonasson, Citrus County Code Compliance Officer. This is case number 202401116, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 6820 North Bighorn Point, Hernando, Florida. Property owner is Cameron Theodore. This property is .23 acres and is zoned CLR MH. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 17 June 2024, photos from a compliance inspection on 17 July 2024, and photos from my final inspection conducted on 17 September 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing order.
What's been proposed as Exhibits A and B are admitted as evidence.
On 17 June 2024, I conducted an initial inspection and observed the property to be in violation. On 17 June 2024, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance mentioned earlier. On 17 July 2024, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 17 September 2024, the property remains in violation. I have received a return of the notice of violation that said that that deceased was on it, and they sent it back to us. So somebody signed for it and then mailed that back. So I assume the property owner is deceased, and the forwarding address is,
But otherwise, you've had no contact
No
with any
contact.
owner
No, sir.
or tenant
No,
or
sir.
otherwise?
No, sir.
What does that flag say on the front? Do you know?
I'm not for sure.
You don't know?
No, I saw that there was a Confederate flag out there, but I
Well,
didn't see
it's
what
not
it
just
said.
a Confederate flag. It has.
I didn't pay much attention to it.
It has a rifle on it,
Oh,
and it
well.
has some words, and I really just would like to know what it says. I think it's interesting.
I did not get close
Never
enough
seen
to-
that before. All right, what's the county's recommendation?
$150 per day.
$15, or excuse me, 15 days to abate the violation. Violation is found, and it'll be $150 a
Thank
day.
you.
I would like to talk about the 1 o'clock hearing with Mr. Lonzo here. Would you mind coming up and just us talking a little bit about it? Sorry.
Do you want it to be on the record, or you want
Yeah,
Kat to
I
turn
want it
off?
on the
Okay.
record. Yeah. Sorry, if you don't mind. The reason is we're going to adjourn until 1 o'clock. But what I wanted to talk about is what the parties. I know that I had signed some motions to continue the case.
Yes, sir.
And I believe one of the bases for it is that the owners are not in the country.
Just got back from Spain, I think 3 days ago.
Okay. Do you expect them here at the hearing?
Yes, sir.
All right. And you're still you're contesting, I assume, that a violation has occurred in each of the cases.
I'd like to talk with both parties to just see if we can get a resolution as to
I
some
would
of these
too.
before
I
we
mean,
can get to that
well,
point.
and you missed it, and maybe you've seen the YouTubes, but at the beginning of every hearing, I give a little speech, and one of the things I always try to ask the people is if they're contesting whether a violation has occurred. Because if there is, fine, you have that right. We'll go through it. If not, then my job, as you know, is just to give an amount of time to bring the property into compliance, and that's fine, you know. So
I believe there's 2 cases left on this. One of them, I just need to get clarity before we decide we're not contesting it, because
Okay.
we're still trying to figure out what specifically is being cited as unpermitted.
Yeah.
Secondary one is more of an issue that I'd like to just discuss because it's kind of a grander preemption
Okay.
discussion that I'd like to see if we
Uh-oh.
can get
Okay.
resolved before we have to go that
Well, the only thing I want to encourage the parties in their discussions is that, you know, I don't know what the county's requesting yet, and I haven't looked at these cases at all. Actually, let me just take a moment to look at what the actual alleged violations are.
17 and 18.
Okay, thanks. I don't think that either of these cases is one in which I normally just assess a fine or something, you know. So normally there's a time to bring the property into compliance in both of these cases. So whether or not, I'll just leave that out there for y'all to think about. And unless there's anything else to take up, does the county have a new code compliance officer?
Yes, we do.
Yes, we do.
You want to stand up, Erica?
And come take a bath.
Ma'am, what is your full name? Can you put it on the record?
Erica Olson.
Are you new at Citrus County?
I am, sir.
And is your training complete?
Yes.
And have you been trained to present at these hearings?
This is my training to present at the hearings. I'll
Okay.
have one next month for you.
Okay. Are you prepared to issue some subpoenas for me?
Yes.
Okay. I have two people I want to subpoena immediately, George Pearson and Amy Becker. So we'll leave May Hampton out of this, and we'll go with those two. How about that?
Great.
Okay. This is hazing, so I apologize.
I'm glad I get to be part of it.
All right. So unless there's anything else, we're going to adjourn until 1 o'clock. Yeah.
I do have one item.
Yeah.
I don't know if my mic is on or not.
There's no touching these mics, they just work.
Okay. Eric Landon, Growth Management Director. I tried not to interfere because I don't need to because they do such a great job. But I did want to bring up one item that's coming up is, as you know, Citrus County is the Nature Coast, and we're taking that very serious. And that's why we bring a lot of these cases for land clearing. Well, I think we're going to be a little more aggressive in pursuing these cases and pursuing the maximum fines. So I just wanted you to be aware if you see our requests increase.
I appreciate.
Why.
Yeah.
And to follow up with that is we're working with the Board of Commissioners to codify those funds going to a particular place. And we're going to start either a beautification or a reforestation program where public spaces will receive those funds. We're going to work with either an arborist or a landscape architect to earmark those funds that are would typically go to the general fund and just to be used for the county, but they're going to go to a specific purpose. So,
And presumably that would be a rationale for your special master to assess the maximum fine instead of something less than that?
Arguably, yes.
I see. Okay. Well, I really value knowing that.
Well, thank you, and I wanted to be transparent, and have it on the record,
Yeah.
and have it
That's
discussed.
why you're going to be
So
tougher.
as we get more aggressive, that's the why.
I really appreciate knowing that. All right. So we're going to adjourn this hearing until 1 o'clock. Thank you.
Thank you.